All right, good morning, everyone. I'm Judge Steinley. This is Division 2 of the Coconino County Superior Court. We're back on the record for the second day of trial in State of Arizona versus Francis Mendoza-Keel, CR 2025-00513. The court will note the presence of both attorneys for the state as well as the case agent and also defense counsel and Mr. Mendoza-Keel. At this time, the jury is not present for the record, and we're a few minutes out from the jury being ready. I understand first where we left off yesterday, we had an issue that had come up about the defense's apparent intention to try to include a greater portion of recording of body cam video that was played by the state during its opening statement. The court had left it off that we would have an evidentiary hearing over that this morning, and asked the parties to brief the issue. Mr. Hartmann-Strawn emailed everyone a little before 6 o'clock last night indicating that he was no longer intending to do that as I took that, but I thought I'd turn it over to you to just make a brief record since that was just in an email, Mr. Hartmann-Strawn.
Absolutely, Your Honor. Thank you. I just wanted to send that email, make sure no one got to work on a brief before I got that out to everyone. Your Honor, we're withdrawing our objection to compel the completeness of record, and that's after consultation with some senior colleagues of mine and my client. Thank you.
All right, thank you. Did the state have anything to add?
No, Your Honor, that's not on that issue.
Okay, and I understand the state wanted to put something on the record regarding the final instructions this morning. I have to confess that I haven't started to work on the final instructions yet. I've briefly looked at each of your lists and then the additional instructions that the defense had asked for. I was planning on working on those over the lunch hour today, but if you want to put it out there so that the court knows what your concern is, Mr. Kent, go ahead.
Sure. So our concern is, after watching defense's opening statement yesterday, there was several statements of law, citation to, I believe it was ARS 13409 and 410. The state believes that those laws are completely inapplicable in this case. Those laws are about justification for police officers to use force, or for 410, deadly force, when making an arrest, essentially. In this case, there's not a police officer on trial for using illegal force. So the state believes that those statutes are completely inapplicable and not relevant to anything with this trial. And while the state didn't object during defense's opening statement yesterday, in retrospect, the state wishes it would have, because it believes those are inapplicable. There is a statute about justification of self-defense that specifically addresses resisting arrest. That's 13404. That might be applicable in this case, but at this time the state is going to move to preclude the defense from arguing that defense at trial. The state didn't receive any disclosure about defense's intended list of defenses until last Wednesday, or Thursday, excuse me, so 6 days before trial. Rule 15.2 mandates that this defense disclosure, including list of defenses, needs to be disclosed to the state within 40 days of arraignment or 10 days after the state's disclosure. That didn't happen. And Rule 15.6 says, in any case, if there's late disclosures, all disclosure must be complete 7 days before trial. That didn't happen in this case. The state had no notice that there was going to be a justification of self-defense presented by the defendant. We had some inkling of that based on the proposed preliminary jury instructions the defense submitted, but we didn't realize the extent to which the defendant's whole opening statement was going to be based on that. Further, to be granted, so I guess this is where it gets to final instructions. Certainly the state believes any instruction based off 409 and 410 should not be instructed to the jury in this case. As to whether an instruction based off 13404 is read, I think at this point the state objects because we're seeking preclusion of that issue. the state is aware that a defendant is entitled to an instruction, a correct instruction of law, if there's the slightest evidence that supports that defense. We haven't heard any evidence in this case yet, but the state's belief is there's not going to be any evidence, either testimony or based on from any of the witnesses or the defendant if he chooses to testify, or the documentary evidence, the videos, that's going to support with the slightest evidence that self-defense was something that was happening in this case. I think that covers the state's concerns at this moment.
All right. Mr. Hartman.
Yes, Your Honor, thank you. I totally understand the state's concerns about the late filing of the 15.1. As this court knows, we did all the preparation for this trial in about 4 weeks. I was in a trial when the last one was scheduled. I apologize, the 15.1 wasn't filed within 10 days. However, you can also file amended 15.1s as you develop new defenses, as you plan to call new witnesses. So amended versions of the 15.1 can be submitted up until trial. Furthermore, I did put on the record in an earlier status conference that I was aware that we hadn't filed the 15.1. That was well outside the 7 days. I'm sorry. At an earlier status conference, I had put on the record that I was aware we hadn't filed the 15.1. I apologize to the court and the state about that. I didn't hear any concerns from the state at that point about that. That was well before the 7 days. The state regularly, in my last trial, filed new charges and amended the charges the morning of trial. So I believe that, the rules allow for both parties to change the charges or the defenses that they're going to be put on. The state is just now noting their objection to the defenses that we plan to put on while we're halfway through this trial. So I think it'd be inappropriate to bar the defendant from using those defenses now. As to whether or not the evidence is going to support the instruction that we're asking for, we haven't heard most of the evidence. We've heard opening statements. In fact, we've heard no actual evidence yet, or witness testimony or anything. So I'd ask for the court to let that play out today, and then you could determine whether or not there's enough evidence to support that instruction. I, of course, believe there is going to be enough evidence. Thank you.
All right, thank you. Did the state have anything further?
Just no, Your Honor. Thank you.
Most of this the court just can't decide just yet because, as you both pointed out, we haven't had any evidence presented yet. The court, that was the same thing the court pointed out in its email to the parties when this justification instruction was asked to be included in the preliminary instructions. That was the same point the court was making in that's something that comes after the case has been presented and the evidence that's been presented is out there, and then its appropriateness to be included in the final instructions or not. That's when the court would make those decisions as to that. I had the same concerns about the use of the arrest instructions related to officers arresting persons, and that how that could possibly be applicable to this case during the defense opening, but there was no objection to that. Certainly the court's not going to interject into that in the middle of the defense's opening. At this point, I have a very hard time understanding how that could be applicable to this particular case. I don't think that it is. As far as justification, I think that what I understand where the state's coming from in terms of the late disclosure, but what the state's asking the court to do mid-trial, I think, is extraordinary. To ask the court to preclude the defense in the middle of the trial, I think would essentially just be inviting that this case, any conviction that you get, be overturned by the Court of Appeals. If I did that to the defense in the middle of the trial, the court knew the case was going to be about justification based upon the Rule 15 disclosure and also the requested instructions. So while it was certainly late, there wasn't an objection before the trial started in that regard. I cannot see how I would possibly do that in the middle of trial. I think that the trial would essentially be somewhat worthless in terms of its being a trial. If a conviction were reached by the state at that point, I think you would just be doing this again if the court were to preclude a defendant from their defense in the middle of the trial. I just think that's would be an extraordinary remedy that I think wouldn't stand. So I have a hard time envisioning doing that. I'm not making a decision that it's applicable at this point either, though, because nothing's been presented for the court to make a determination as to whether or not any evidence as to justification is there. But it is a very small, any inkling of there being justification is really all it takes for the court to be required to give that instruction, and then for the state to have the burden to prove that it wasn't justified. So at this point, I'm not going to decide that. I want to hear from the witnesses first. And then when we are actually going through the instructions, that's when the court will make its decision on that. But just preliminarily, I'll say that I tend to agree that the method of arrest and arrest how made, I doubt that those are applicable and appropriate to the case. But the court suspects that justification, if there's anything there for that, whether it's from the video or testimony or whatever the court sees, that probably would, but the court has to see all of that first. So that's where I'm going to leave it at this point. Do we need to place anything else on the record, or can we call the jury down?
Just to supplement, and if the court is inclined to review this or defense before we talk about final instructions, I think the leading case on this is State v. Medina. That's 244 Arizona 361.
Could you give me the site one more time?
244 Arizona 361.
361. Okay.
But other than that, we are ready to proceed and call the jury.
Did you say the name was Medina?
Yes, Your Honor.
All righty. Thanks. All right, Mary, we're ready. If you want to let the jury or let the bailiff know that we're ready for the jury.
I'm going to bring our witness into the courtroom.
case you can't find it, but it also might be bad. I don't know. One, the jury.
Good morning. Please be seated. All right, and good morning. The record will reflect the presence of the jury at this time. Welcome back to each of you. Hope you each had a good, had some corned beef and cabbage or whatever you do for St. Patrick's Day last night, and we're ready to go here this morning. So at this time, I'm going to turn it over to the state to call its first witness.
Thank you, Your Honor. The state calls Howard Leventhal to the stand.
All right, thank you, Mr. Leventhal, if you'll come forward, my clerk will swear you in.
Do you solemnly swear under the penalty of perjury the testimony you are about to give is the truth, the whole truth, and nothing but the truth, so help you God?
Hi, Your Honor. Good morning. And good morning, Mr. Leventhal. You testify here this morning. You're welcome to move the chair, the microphone around, however is best for you. These microphones are directional, so they work the best when we speak right into them rather than an angle like I am right now. So if you'll do your best to do that, that'll make sure that the jury hears you the best and we make the best record with the recording. And then I think you have some water there. If there's anything that you need, just let us know. But when you're ready, if you'll please state your full name for the record.
Howard Leventhal.
If you'll please spell your last name for us.
Leventhal.
And I'll turn it over to the state for your direct examination, Mr. Kent.
Good morning, sir. Let me know if you have any trouble hearing me and I can speak up. Could you please just briefly introduce yourself to the jury?
My name's Howard Leventhal. I've lived in Ash Fork almost 30 years.
So you say in Ash Fork, where more specifically do you live? Do you live in Coconino County?
Yes.
Okay. And what neighborhood?
It's called Kaibab Estates.
Thank you. Do you know the defendant, Francis Mendoza-Keel?
Yes.
How do you know him?
He became a tenant.
And this tenancy, was that in the same area of Kaibab Estates?
Yes, it is.
I want to turn to April 22nd of 2025. Do you recall that date?
Yes.
Did you have any interactions with the defendant on that date?
Yes, I did.
How did that start?
I was showing somebody else a piece of property, and I was coming back, and Francis was outside in front of his place, and I stopped to try to get the rent.
So you were having trouble with rent payments?
Yes.
How did that go when you stopped to talk to him that day?
Well, I was in my car. He was out in front of the house, and I basically stopped and asked, "When are you going to come work and catch up with the rent?"
How did he react to that?
He just was in a different mindset. He walked back and forth, came to the car, put his hands on the car, shook the car like it was nothing, and then started blaming me for not having his family.
You said he came up and shook the car.
Yeah, put his hands on the roof.
How did you feel when this was happening?
Well, I felt the car moving and I couldn't believe it. And I got a little bit nervous at that point because he was this close to me.
Were you scared at this point?
Oh, yeah.
Did he touch you in any way during this?
Yeah, he hit me on the side of the face. And as soon as he hit me, basically, I just got out of there. I took off.
So let's just back up. So you're sitting in your car when this happened?
Yes.
Is the door or window open?
The window is open, yes.
So you said he hit you at that point?
Yes.
Can you just describe, what kind of hit this was?
Well, it would have been a harder hit, but I kind of moved, so he only hit half of my face, basically back here. So when I got home, I had all kinds of grease and stuff that come off of his gloves.
Okay. Were you wearing glasses at the time?
No. Oh, yeah, sunglasses, yes.
Objection leading.
Sustained. If you'll rephrase the question.
Did you have anything on your head at that time?
Excuse me?
Did you have anything on your head during this time?
I had my sunglasses on.
Did those stay on your head?
No, they went flying right off to the dashboard.
And I think you said you sped away in your car after, was that immediately following this?
Yeah, because he started yelling even louder, and I could see he was in some kind of frenzy. And I thought for a split second, I wouldn't want my children near this guy. I mean, that's what ran through my head, how bad he was crazy.
I understand. Did you report this to law enforcement?
Yeah, when I got home.
And did they come out and speak to you that day?
Yes, they both did, two of them.
And did you tell them everything you're telling the jury today?
Yes.
Objection leading.
Overruled.
Was the answer to that yes?
Yes.
Later that day, after you spoke with law enforcement, did you see Mr. Francis Mendoza-Keel anymore that day?
No.
And do you know what Mr. Mendoza-Keel looks like? Are you
What do you
familiar with his physical appearance?
Yes.
Do you see him here in this courtroom today?
Yes.
Could you point out where he's seated and an article of clothing he's wearing?
In the middle with the white shirt.
Let the record reflect the witness has identified the defendant.
Any objection?
No objection.
The record will reflect the identification of the defendant by the witness. Go ahead.
No further questions.
All right, thank you. Cross-examination, Mr. Hartmann-Strawn.
Yes, thank you, Your Honor. Thank you for being here today, Mr. Leventhal. I just have a couple follow-up questions. Did you have a written lease agreement with Francis?
Objection, relevancy.
Overruled.
I didn't.
Yeah, so I'll just repeat that question. Did you have a written lease agreement with Francis regarding the property he was renting from you?
Yes, I issued him a one-page receipt stating month to month and the amount.
Did you provide the state with a copy of this lease agreement?
Same objection, Your Honor.
Overruled.
Sorry, just to repeat that question. Did you provide the state with a copy of this, or law enforcement with a copy of the plea agreement?
No, no
Or,
one
excuse me, the
asked
plea
for
agreement,
that.
excuse me, the lease agreement?
No, no one asked for that.
Okay. At dispute here in this argument that you said you had with Francis was sort of the terms of the lease and whether he was meeting those, right?
Yes.
And it was your feeling he wasn't, correct? It was your feeling that he wasn't meeting the terms of the lease, is that correct?
Absolutely.
Did the terms of the lease include some amount of labor in return for rent?
No, not at all.
Was he, though, doing some labor in return for rent?
Yeah, for about the last 2 months because he didn't have a job, and I did what I could to help. So I hired him, but he was a real problem coming to do his job.
Okay. And I think that's very charitable to give somebody an opportunity to maintain shelter and have other ways to sort of provide.
Objection. Counsel's testifying.
Sustained.
Sorry. So you had this agreement that was written, but it sounds like it had been modified to include some amount of labor. Is that correct? You guys had sort of, we would call it in legal terms, an oral modification. You guys had a discussion, and now you sort of had new terms where he was doing labor in return for some of his rent. Is that correct?
Yeah, it was a verbal.
Okay. And it was Francis's opinion that he was meeting those terms by doing physical labor. Is that correct? And that was why you guys were disagreeing?
Objection, foundation.
Could you repeat the question?
Yeah, I'll rephrase. You guys were having a disagreement that day because you felt that Francis wasn't meeting the terms of his agreement, but Francis did feel that he was living up to the terms of this oral agreement you had struck. Is that correct?
Same objection.
Overruled. Go ahead.
I'm basically just trying to get to what this disagreement was about. So you felt that Francis was no longer meeting the terms of his lease agreement, but he did feel that he was, and that's why you guys were disagreeing, right?
And to him, yes, not to me.
Okay. But you guys at this point are operating under this spoken agreement, this oral agreement that had kind of changed the original written lease, right? Because now he's doing labor in return for rent. Is that correct?
Yes.
So the disagreement was really whether the labor he was doing was sufficient. Is that fair?
Well, it was by the hour.
Okay. What kind of labor did you have him doing?
Yard work, landscaping.
Okay. How were you keeping track of how many hours he was spending on it?
Well, he
Objection,
would-
Your Honor. Can we approach?
You may. I assume you have an objection on relevance.
Yes, Your Honor. I think we're way outside the bounds of relevance. Sorry, this is Kevin Kent for the state. I mean, the idea of this disagreement about rent terms, lease terms, really isn't relevant to whether there's an assault committed. I mean, it's relevant and to the extent of motive. There was a dispute, but the minutia of changes in this rental agreement just has no relevancy, and I think is going to confuse the jury. And I believe defendants' intent to bring this out is to provide sympathy to the jury for someone who's having trouble paying their rent, which I don't think is relevant.
Up to this point, the fact that there was a tenancy was brought out by the state in its direct examination. The state objected as soon as the defense was getting into the terms of the lease or the existence of the lease, etc. I allowed that initially, thinking that the doors open based upon the tenancy being brought up by the state of the courts going to give the defense some opportunity to go around that. I tend to agree that we're getting a little bit far afield here, getting into the changes and these sorts of things. But what's your position, Mr. Hartmanstrand?
Yeah, this is Dana Hartmanstrand for the defense. I wish I thought about the sympathy angle, but that wasn't my intent. I wish I thought of the sympathy angle. That wasn't my intent at all. This whole arrest arises from this confrontation between Mr. Leventhal and my client. I'm trying to get at why there was a confrontation. So I'm just trying to get to the genesis of this entire issue. I'm about to move on. I just needed to get to the fact that there was an oral agreement that modified the regular agreement, and they're now disagreeing about the terms of the oral agreement. I'm done.
All right. I think you've done that.
Yeah.
So I'll allow you to ask just one or two more questions to wrap it up and then move on.
And I can move on
this
right now.
issue. Okay.
Thank
Very
you.
well. All right, you may proceed.
So you and Francis had this disagreement. Then you later reported to law enforcement that during this disagreement, Francis had assaulted you. Is that correct?
Yes.
And you believe you reported to law enforcement at the time that he sort of smacked you in the back of the head. Is that correct?
This side of my head.
Okay. And I think at the time you told law enforcement sort of that you were slapped in the back of the head and causing your glasses to fall off. Is that correct?
Well, I was sitting there and he hit me with his hand, so it was in that motion, that forward motion, that the glasses came off.
Okay. And I think you told the state just now that it was sort of like a closed fist strike that sort of grazed your head. I think you told law enforcement at the time that in fact it was an open hand slap to the back of the head. So could you just clarify which of those two it was?
It was an open hand slap.
Okay. So it wasn't a closed fist strike that
No.
grazed you. Okay.
It was just his open hand doing the same thing.
I thank you. No further questions.
Any redirect?
No, Your Honor.
And do we have any questions from the jury? This is our first witness, so I always try to take a moment to make sure you realize you have the opportunity to ask any questions of the witness that you have. You have forms to do that. If you have any questions for the witness before we excuse them, you write your question on that sheet, you pass it down to Ernie, and then we look at the questions, make a determination whether or not legally we can ask those questions or not, and then I ask the questions when we can. So if any jurors had any questions for this witness, this is the chance to do that. So with that long explanation, were there any questions that the jury wanted to ask of the witness? I think we are going to have one. Okay. All right, looks like we have one question, if I can have the attorneys approach. All right, this is Judge Steinway. We have one question from the jury. It is, was there an earlier incident leading up to this one?
Do you know my position on it?
Yeah.
This is Daniel Hartman, strong for the defense. I would object to that question just on relevancy grounds. Also, they don't know this obviously, but there's nothing in the facts to support that. There's no allegations of prior incidents. There's nothing in the facts to support a prior incident. There's no allegation of that. I also don't think it's relevant because we're just talking about one assault that led to one arrest.
The state would ask the question. We do think it is relevant. I think it goes to the defendant's motive to attack the victim. We had a lot of questions about kind of what led up to this in terms of rent disagreements, and I think the juror's question is fair given all of that, whether there was something else that precipitated or led up to this altercation.
The court sees it that if there were some prior incident that would probably be a prior bad act that would have required a 404B analysis before it coming in. I have no idea what door would be opened up by opening that, by asking that question, and whether or not it would be some sort of prior incident that would actually potentially mistry the case. So unless you can really convince me that there's no risk on that.
I don't know what the answer to the question is, so I think I understand the court's point.
Yeah, I'm not going to ask it. I think that anything, any other prior incident for it to be relevant is something that I could ask. needed to be addressed and analyzed by the court under the rules. So I'm not going to ask that question. The second one we have is, how long was the work for rent?
How long was the work?
Yeah, it just says, how long was the work for rent? I think they're trying to get at the terms instead of how much work he was supposed to do.
This is Daniel Hartmann-Strawn for the defense. I would have no objection to that question.
Mr. Kent?
No objection.
I will ask that. Then it says any curse words exchanged.
No objection.
I guess no objection.
I'll ask that. I don't think there's any harm in either of those. All right. Thank you. We have a little slip. And this one says, how long has Francis been living there? When did the verbal modification happen?
No, this is Daniel Hartmann-Strawn for the defense. No objection.
I do object to that question.
There's really two questions. So the first question was, how long has Francis been living there?
So I do object to that question. I'm concerned it could get into where Francis is living now, which is in jail. Just because if it said before this, I don't think I'd have that objection. So the state does object to that question.
Mr. Hartmann-Strawn?
Yeah, this is Daniel Hartmann-Strawn for the defense. I'd have no objection to that question if the court wanted to rephrase it as, how long had Mr. Mendoza-Keel been living at the residence at the time of the conflict or something like that.
What would the state's position be if the court just changed the sentence to, how long had Francis been living there at the time?
I wouldn't have an objection to counsel asking that question if they want to follow up. I don't think we should be editing the jurors' questions, so I do object.
Right. I won't ask that question, but after I ask the questions I am asking, I'll invite both parties to do a follow-up, and if you want to ask the modified question, either of you, you're welcome to do so. Next is when did the verbal modification happen?
This is Daniel Hartmann-Strawn for the defense. We'd have no objection to that question. I think it leads as to sort of maybe how this conflict began building between the two parties.
Can you repeat that?
Sorry, I'm trying to be quiet. I'm so loud normally. This is Daniel Hartmann-Strawn for the defense. We'd have no objection to that question being asked. I think it gets to sort of the genesis of this whole conflict between the two parties.
The state does object. I don't see the relevancy about whether modification of the lease, so my same objection from earlier, I don't see how the modification of lease terms really has any relevancy to whether the defendant in fact hit and disturbed the peace of the victim.
Right. I am going to ask that. I don't see any issue with it. The basic terms and the change, it's clear to the court that that's what precipitated the whole incident on this date. The court thinks it is relevant, and I don't think that there's any great risk of harm in asking it, so I'll ask it for the jury. Thank you. Anyway. All right, Mr. Leventhal, I have a few questions that I'm going to ask from the jury. The first is, when did the verbal modification happen?
I'd say going into the 4th month of him being on the property.
All right. And the second question is, How long was the work for rent?
I didn't understand that.
That's exactly how it's worded. How long was the work for rent?
Are you asking how long we were trading?
It's not my question exactly, so if you could just answer it as best you can, or I'll give the attorneys the opportunity to follow up and ask questions to try to clarify.
It was for, apparently we were in our second month of working. He would work hours, I'd give him a receipt for his hours. So I was keeping track of it. And then after the second month, that's when he decided not to really pay me.
The last question is, any curse words exchanged?
I would imagine so.
All right, thank you. And I'll turn it over to the attorneys to do any follow-up questions that you'd like. I'll start with the state. Mr. Kent?
How long in total had Francis been living on your property as of April 22nd, 2025?
About 6 months.
Nothing further.
Mr. Hartmann-Strong?
No further questions, Your Honor.
All right. And just one more time, any further questions from our jury? There are none. May this witness be excused?
Yes, Your Honor.
And is the witness still subject to recall?
No, Your Honor.
All right. Mr. Leventhal, you're excused and you're free to go about your day. You, of course, can stay in the courtroom or you can go home, whatever you wish to do.
Thank you very much.
All right. The state may call its next witness.
Thank you, Your Honor. The state will call Corporal Colin Knight.
All right. Corporal Knight, if you'll come forward.
You solemnly swear under the penalty of perjury the testimony you are about to give is the truth, the whole truth, and nothing but the truth, so help you God?
Hey, good morning, Corporal Knight. I'm Judge Steinle. As you testify here this morning, the microphones are directional, so if you'll speak directly into it, it works the best when we go right into it instead of at an angle like I'm doing with you right now. You can move the seat around, the microphone around, whatever makes you comfortable there. We've got water for you if you need it at any time. And then when you're ready, if you'll please just state your full name for the record.
So full name is Colin Reed Knight.
And if you'll spell your last name for us for the record.
It's Knight.
And the state may proceed with its questions when you're ready.
Thank you, Your Honor. And I just want to confirm we will be displaying some exhibits. Do I have control on my end when I'm ready?
You don't yet, but when you're ready and you tell me that you're ready with the specific exhibit to publish, that's when I'll turn it over to you.
Okay. Thank you, Your Honor.
Just tell me when.
Okay. Good morning.
Morning.
Can you please introduce yourself to the jury?
I'm Corporal Colin Knight.
And you live around here somewhere in this area?
I live in Flagstaff, yes.
Okay. And what is your occupation?
So I'm currently employed with the Cookman County Sheriff's Office as a corporal on patrol in the Williams District.
Okay. How long have you been with the Sheriff's Office?
So I've been with the Sheriff's Office for a little over 9 years, 8 of which has been on patrol.
Okay. Have you received any training prior to becoming a law enforcement officer?
I have.
Can you describe that for us?
So I attended the Southern Arizona Law Enforcement Training Center in Tucson as a 17-week training course to be able to be certified as a peace officer in Arizona.
Any additional training beyond that?
So for regular patrol duties and functions, I've got just intoxilizer training for DUIs and the quality assurance specialist training for that as well.
Okay. So I'd like to turn your attention to April 22nd, 2025. Were you working that day?
I was.
Did you have any specific shift?
I was on day shift that day.
Do you know about what hours those would have been?
I'm not sure if it was before a schedule change, but usually about 5 or 6 o'clock in the morning until 4 or 5 o'clock in the evening.
Okay. And how did you become involved with this case?
So I became involved with this case because I saw that Deputy Willis was assigned to a assault case and was originally responding on his own. So I responded to back him up.
Okay. Did you eventually respond to the area where this incident took place?
I did.
Where was that?
So the incident itself took place at 100 West Canyon Drive in Kaibab Estates West, north of Ash Fork.
Okay. Is that within Coconino County in this court's jurisdiction?
It is.
What did you do when you arrived there?
So when I arrived at the West Canyon address, so upon arrival at the West Canyon address, I observed a male subject who was ultimately identified as Francis Mendoza-Keel outside of his building, his residence, filling sandbags.
Okay. And when you arrived there, were you in a properly marked law enforcement vehicle?
I was.
Did you have on your uniform?
I did.
Did Deputy Willis have on his uniform?
He did.
Do you see the individual that you saw at 100 Canyon in Kaibab Estates West here in the courtroom today?
I do.
Can you describe where he's sitting and what he's wearing?
So he's seated at the bench in front of me here, wearing a suit and a blue tie.
Can you just say what color suit it is?
It's a black suit.
Your Honor, may the record reflect the witness has identified the defendant?
Any objection?
No objection.
The record will reflect the identification of the defendant by the witness. You may proceed.
Thank you, Your Honor. Do you recall what the defendant's demeanor was like when you arrived?
So upon arrival, he was immediately uncooperative and belligerent with us.
Was Deputy Willis talking with him while you were there?
He was.
Did Deputy Willis attempt to place the defendant under arrest?
He did.
And what happened next?
So after Deputy Willis advised that Francis was under arrest, he approached him, and Francis immediately began backing away from him. As Deputy Willis attempted to restrain Francis to detain him in handcuffs, they began fighting. I observed Francis attempt to, what appeared to me, put Deputy Willis in a headlock. I attempted to separate the two from each other, but wasn't able to at that point.
Thank you. Have you reviewed State's Exhibits 1, 2, 3, and 4 in this case?
I have.
And were you wearing your body camera on the date of this incident?
I was.
And was it active during this incident?
It was.
And have you reviewed your body camera as well?
I have.
And did it capture the events as they occurred accurately?
It did.
Your Honor, the state would move to admit State's Exhibits 1, 2, 3, and 4.
Any objection?
No objection.
State's Exhibits 1, 2, 3, and 4 are admitted.
Your Honor, may I have permission to publish?
You may.
And publish 1, 2, 3, and 4.
And are you ready?
Yes, Your Honor.
Okay.
In publishing State's Exhibit 1, Corporal Knight, where are you in this scene?
I'm the one looking at Francis and Deputy Willis.
Okay, so is this, I see someone with a beard, a hat, sunglasses in the right corner of the screen. Is that you?
That would be me, yes.
Objection meeting.
Overruled.
And who is the other deputy there?
That would be Deputy Willis.
Sorry, I'm going to find a good place. All right, and who is in the orange shirt?
That's Francis.
Is that the defendant?
It is.
Okay. And this is this when you had just arrived at that 100 Canyon?
I believe it's shortly after.
And had Deputy Willis been talking with the defendant for some time before this video?
Objection leading.
Sustained.
Corporal Knight, were you part of the discussion with Mr. Mendoza about what had happened that day?
Directly, no.
I'm going to play the video now. Actually, before I do, can you explain a little bit about body camera recording as far as when audio comes in?
So when the body camera is on standby, it has a continuous 30-second loop. So the moment that you activate your body camera, it'll play the 30 seconds prior to you activating the camera, but it won't have sound at that point.
Thank you. Corporal McGregor, excuse me, Corporal Knight. During this incident, you had described the defendant's demeanor as, can you describe that again for us?
So he was uncooperative and belligerent with us upon arrival on scene.
Okay. And so did you have any indication, though, that this was about to occur?
Not until he started backing away from Deputy Willis after being told that he was under arrest.
Corporal Knight, how did you feel during this incident?
I mean, at the moment that he began to resist and actively fight with Deputy Willis, originally I was feeling like Deputy Willis was in danger at that point, given the fact that it appeared Francis was trying to put him in a headlock.
And if we rewind here, can you describe what actions you're taking here? Were you punching the defendant? Were you kicking the defendant? Can you explain what you're trying to do here?
So at the beginning of the video, when Francis and Deputy Willis began to fight, initially I was attempting to separate the two by placing my left arm in between them and pulling back on Francis. When that didn't work, I delivered a knee strike to the lower lower portion of Francis's back. I was still unable to separate the two, at which point I did deliver multiple close fist strikes to Francis's face.
Okay. Just want to focus on this initial part, though. Because it doesn't look like you're striking him here. pause it right here.
I'm sorry?
I just want to pause it right here. Corporal Knight, did the defendant strike you during this encounter?
He did.
More than once?
I believe so. It was a pretty rapidly evolving situation.
Okay. Can you explain that ending sequence there? It looks like you and the defendant are fighting.
Yes. So after I was unable to separate Deputy Willis and Francis, and I delivered the strikes to his face, Francis grabbed onto my vest, at which point he directed his attention at me. He was able to break free from Deputy Willis, at which point he jumped and swung in an attempt to hit me at the same time. We began to fight, pretty much locking our arms behind each other's backs in close proximity. While we were in this position, Deputy Willis attempted to deploy the taser first time. After that first deployment, I could hear Francis say, quote, "I like it," end quote, while we were still fighting at that point. And then Deputy Willis deployed the taser a second time. And shortly after that, Francis fell to the ground.
Thank you. Publishing States Exhibit, excuse me, Your Honor. Permission to publish States Exhibit 4?
You may.
Sorry. Corporal Knight, do you recognize this scene?
I do.
Where are you in this scene?
I am in the upper left corner.
Oops, sorry.
Kind of in a crouched position.
Okay, sorry, give me 1 second here. Okay, I'm not going to get this to work. And is that the defendant jumping towards you?
It is.
I'm just trying to get the call. Lights up there. Sorry about that. I was trying to zoom in there, but I believe you just testified that is you crouching down. Is that right?
It is.
Okay. How would you describe your posture at that moment?
My posture. Sorry.
Yeah.
So I'm crouched down, with my head semi-ducked.
Okay. Would that be an offensive position or a defensive position?
Defensive.
Permission to publish States Exhibit 2?
You have permission for all.
Okay, thank you, Your Honor.
Objection, Your Honor, foundation on?
It's already been admitted, overruled.
Deputy Knight, is this Deputy Willis's body camera?
It is.
And where are you in the scene here?
Currently in front of Francis, but you can't see me in the video because I'm pretty much under Francis at that point.
Okay. And that's the defendant there attacking you.
It is.
And it looks like in the shadow you can see someone. Is that Deputy Willis?
That is.
And did Deputy Willis's initial use of the taser bring compliance?
It did not.
Was it necessary to deploy a second taser?
It was.
Objection leading.
Did Deputy Willis?
Sustained.
Sorry, Your Honor. I apologize.
It's sustained if you'll just rephrase the question.
Did Deputy Willis have to deploy a second taser?
He did.
Publishing States Exhibit 3.
Is there anyone else here with me? No. Okay, at this time, we have Mr. Burrows. What do you mean? Holy my life.
Corporal Knight, can you tell us whose audio that was that we just heard? Was that from your body camera or Deputy Willis?
That was from mine.
And Corporal Knight, did you suffer any injuries from this attack?
Minor injuries.
Did you have any other involvement in this case?
No.
I have no further questions at this time, Your Honor. Thank you.
All right, thank you. Cross-examination.
Thanks for being here today, officer. So on April 22nd last year, you went out to Howard Leventhal's property, is that correct?
I did.
What was the purpose of going out to that property?
So I was backing Deputy Willis for an assault case, or investigation, sorry.
And so your initial purpose going to that property was to investigate further a report you had received?
So my purpose was to back Deputy Willis, who was, yes, investigating a report of an assault.
What is general, you're a corporal in this department, so I assume you have some higher level experience in training in this department, is that correct?
Can you ask the question again?
You're a corporal with the sheriff's office. I assume denotes that you've been with the department for some time. Is that correct?
Yes.
So would it be fair to say you are fairly familiar with department policy? You received a fair amount of training.
Yes.
When you go out to investigate a crime, what are sort of the steps you go through when you encounter the suspect?
When we encounter the suspect?
Mm-hmm.
It depends on the sequence that the investigation goes, but usually we want to get all sides of the story. So first thing that we would do when we encounter a suspect is initially identify them, and then interview them to get their side of the story.
And when you go to do that interview, do you ever have suspects who would prefer not to speak with you about what happened, about their side of the story?
We do.
What is your general response when someone responds in that way?
Again, it all depends on the situation, and depends on the investigation that was conducted beforehand.
What might lead you to arresting someone following refusal or someone declining to answer further questions?
So it could depend on if any witnesses were present that witnessed the incident occur, any comments made by the suspect as well.
Okay, in an instance, let's say, kind of like the one we have here, where the suspect, gives you their lawful name, or their truthful name, excuse me, as they're required to by law, and then at that point doesn't want to answer further questions, what might lead to you making the decision to take someone under arrest?
Again, it could depend on witness statements or victim statements, and then comments made by the suspect.
So when you say depending on witness statements, can you elaborate? Like what in a potential witness statement would lead you to think we got to make an arrest here?
So if the witness is giving us a statement that's consistent with what the victim was telling us had occurred as well, then we could potentially make an arrest based off of that.
Okay, so it's the feeling that you have stronger evidence maybe than just he said kind of situation.
Yes.
How, would you say you're familiar with the facts of this case? What was put in the report, by Deputy Willis and by yourself?
Yes.
Do you think that there was enough here on scene to arrest Francis, despite the fact that he, had cooperated insofar as he's required to by law?
Objection, Your Honor. This is calling for a legal conclusion.
All of the parties approach. I'm sorry, I didn't want to draw more attention to it by having you repeat the question, but could you repeat the question as close to verbatim as you just asked it?
Yeah, so I just asked him if based on his this is Daniel Hartmann-Strawn for the defense. I asked him, based on his understanding of the facts of the case, whether or not he thought there was reason to arrest Francis, the defendant. And that was basically my question. I'd be happy to evade this based on your training and experience and go from there.
And the objection was calls for a legal conclusion.
This is Javen Orocho. Yes.
All right. Do you have anything in response, Ms. Hartman-Strawn?
Part of law enforcement's job is to act on violations of law, and then they forward it for charging. So it's true that they don't get to make dispositive determinations on whether someone's eventually guilty or not. However, this is part of his actions in the field. Our entire defense is that, one of the three prongs of our defense is that the arrest was unlawful and unnecessary. And so for those reasons, this goes right to the heart of our justification defense.
I'm going to sustain the objection and move on with another question. The objection is sustained.
So you guys went out to do this. So when you guys were out at the property talking with Francis, did you ask him questions, like you said, because you want to hear all sides of the story? Did you ask him questions about what had happened with Howard?
I didn't.
Did Officer Willis ask him questions?
Yes.
Did you or Officer Willis give him the opportunity to go back to the station with you out of custody to answer further questions?
No.
Did you give him the opportunity to retain counsel and answer further questions?
No.
Would you say, based on your experience, that it is common to arrest someone for a misdemeanor assault allegation when they refuse to ask further questions at the scene?
Objection, Your Honor. Same objection, calling for a legal conclusion.
Sustained.
Is it true you can give someone just a citations and a summons to appear in court at a later date for a misdemeanor?
Objection, Your Honor. Same objection, legal conclusion.
I'll allow it. Go ahead.
I can ask the question if you want. So, if you are writing someone up for, or someone is going to be charged with a misdemeanor through your department, is it possible just to give them a citation and then a summons to appear for court in the future?
It is possible, yes.
What causes you to forego that route and instead arrest someone?
It's discretion, officer discretion.
What factors might go into whether or not you go down the path of arresting someone?
Objection, Your Honor, relevance.
Sustained.
You brought Francis to the ground with the help of Officer Willis and his taser, is that correct?
It is.
Did Francis make any other statements to you?
Before or after?
After he was brought to the ground.
Objection, Your Honor. This is hearsay as to the defendant.
Overruled.
Your Honor, can we approach?
You may.
Yeah.
So at this point, there's been just a question as to whether or not any statements were made, not about what the statements were or anything. So the objection from the state, go ahead.
This is Kevin Kent for the state. The objection is hearsay. I guess the question of were statements made is not hearsay, but the content of those statements absolutely is hearsay without any proper exception, and the court should not admit any responses to questions such as that.
All right, Mr. Armstrong.
This is Daniel Hardman-Strong for the defense. I don't plan on going past this point.
And that's why I overruled the objection. At this point, there hasn't been any attempt to elicit any actual statements. So if the defense goes there, that's what the court would anticipate doing. But at this point, I'll continue to sustain and overrule the objection.
Thank you.
The objection is overruled at this point.
Thank you, Your Honor. So sorry, I'm just going to say exactly that question again. So after Francis is tased, you and him have gone to the ground. You're now putting him in handcuffs. At that point, did Francis make any further statements, if you recall?
I mean, he did make a lot of other statements after the incident occurred.
Okay, then that's perfect. Thank you so much. Just a few final follow-up questions. Did you or Officer Willis give any instruction as to Francis as to why he was under arrest?
No.
So you didn't inform Francis why he was under arrest?
There wasn't time from the time that we told him that he was under arrest to the time that the altercation occurred.
Okay, so just to put not too fine a point of it, but so at the time that Francis was placed under arrest, he didn't know why he was under arrest. Is that fair?
Yeah.
Okay. Did you believe that physical force was necessary immediately to effectuate that arrest?
Objection calls for legal conclusion.
Sustained.
Aaron, can we approach?
You may.
This is Daniel Hartman-Strong for the defense. Your Honor, again, this gets into the same thing. The cops have to rely on legal principles in order to effectuate legal arrests. Our defense, our justification to defense has to rest on whether or not these three prongs are met. One of them is whether the defendant knows whether he's under arrest or is informed why he's under arrest. The second one is whether the arrest itself is lawful and whether force is immediately necessary. So I just have to get at those three prongs. And I realize that the court disagrees with this, but I think that 409 defines a key term in 404 or whatever it is, or 406, that is part of that justification, self-defense. And so I have to get at these elements because it's going to be a key part of my closing that the officers didn't hit these elements for a lawful arrest, and therefore self-defense is justified.
All right, from the state.
You know, the same objections we raised pre-trial. 409 has no application in this case. 409 is about officers who are charged with using excessive force. That is not the facts we're under in this case. Whether there's a 404 defense justification argument that they want to get at, the language of 404, I think it's 13404B, I believe, says that one is not permitted to use force to resist a lawful or unlawful arrest unless, I can't remember the exact language,
The issue is that she just,
unless the physical force used by the peace officer exceeds that allowed by law. We're not even close to that here. This court has already sustained the state's objection on this exact, nearly identical question. The idea of the defense not being able to present a full defense under 409, which is not applicable, should not be entertained. The court should sustain the objection.
yeah, this is Daniel Hartman's on for the defense. I don't think the court sustained an objection about this. I think, in fact, actually just overruled the objection as allowed. I believe the court just overruled the objection on that grounds, and I was allowed to ask my question if I recall what just happened here. Also, my defense, I totally understand what it says in 404. However, I have to go off of what defense I can find in this case. And here it's going to be the attempted use of unlawful physical force. It's not going to be about whether the arrest really is unlawful or not, but to get whether officers' justification for using physical force in law enforcement. This is in their easy post instructions. It's what they study at the academy. They have to meet these three. So if I'm going to prove that there's unlawful physical force, I have to prove that 409 was not met. This is the way he has to meet to be lawful physical force as a law enforcement officer. I'm trying to prove that this wasn't supported, and if 409 wasn't supported, then he gets to use self-defense under A.
Why is it necessary to ask this officer that question and have him draw that conclusion for you?
Well, no, I'm just trying to have him hit whether he was meeting these three requirements to use physical force in law enforcement. And so I'm asking questions like, I asked exactly the term, did he think he was immediately necessary? Or did such the person make known the purpose of the arrest? And these are exactly the questions I'm asking.
I agree with the state. The objection is sustained. The objection is sustained. All right, thank you. Redirect.
We'll have no further questions, Your Honor.
Do we have any questions from our jurors? And I'll have counsel approach. The first question is, what type of injury did you sustain?
No objection. This is Kevin Kemp for the state. No objection.
Is the defense no objection?
All right, I will ask that question. Next, did you seek medical attention for injuries?
For the state, no objection.
For the defense, no objection.
I will ask that question. Next is, was Francis's family there?
Kevin Kemp for the state, no objection.
This is Daniel Hartman for the defense. I would object just based on relevancy grounds. I don't see whether his family's around or not, what that has to do with anything. And there's nothing in the facts about that. So
I also don't think it's relevant. I'm not going to ask that question. What did Mr. Leventhal say before going to Francis's property?
I don't have an objection.
this is the defense. We'd object. it's fairly vague what that means. I don't know whether they're getting at Mr. Leventhal's statements to law enforcement before they went to the property, or whether it's talking about prior communications on police or the property between Francis and Howard. I just had no idea what that question's about, so we didn't check.
The principal, so I agree that this witness didn't talk to Mr. Leventhal and wouldn't get anything that he heard from Mr. Leventhal would also be hearsay.
And actually, Your Honor, we'd also object on those grounds.
I'm not going to ask that question. Third is, why didn't you write Francis a citation?
The state does object. It's been asked and answered. The answer was discretion, but we also don't think it's relevant.
This is the defense. This gets at a core part of our defense, that there were other ways to go about this other than trying to use unlawful physical force. So we'd ask that it be, or we would have no objection to it be next.
I'm going to ask it. Last, did you tell Francis he was going to be arrested if he didn't answer your questions?
Is the defense? No objection. Again, I think it gets to the heart of whether or not the arrest was necessary, immediately necessary, and also just gets at, the circumstances that surround this assault.
No objection from the state.
I will ask that question. Let me just make sure. Okay, that's it. Right, I have a few questions that I'm going to ask from our jurors. First is, why didn't you write Francis a citation?
So again, it's the decision to full custody arrest versus cite and release is fully discretionary based on the officer that's in charge of the case or that's investigating the allegations.
Did you tell Francis he was going to be arrested if he didn't answer your questions?
I did not. I never heard a statement made of, we're going to arrest you if you don't answer questions either.
Did you seek medical attention for injuries?
Yes.
What type of injury did you sustain?
So I had a few scratches and abrasions. Most of them were to my arms. And there were photographs of those as well.
All right, thank you. And any follow-up questions from the state?
Corporal Knight, were medical services called for you or the defendant or both?
So medical services were called primarily for Francis. As per policy, once the taser is utilized, whether the subject requests medical attention or not, they're required to at least be called. Medics are required to at least be called.
Is it fair to say they were not called just for your injuries?
Yes.
But would it be also fair to say primarily for the defendants?
Yes, medics were called primarily for the defendant.
Did you ask him if he wanted medical services?
I told him, I believe at one point, that I was having paramedics come to our location, but he stated he didn't want them and just wanted to go. But again, per our policy, I still had paramedics come.
No further questions.
All right, thank you. Any follow-up from the defense?
No further questions, Your Honor.
And may this witness step down?
Yes, Your Honor.
And is this witness subject to recall?
Not from the state.
All right. In that case, and not from the defense?
We'd release the witness, Your Honor.
All right. With that, you're excused. All right, and with that, I think we've come to a good time to take our morning recess, so we'll take a break now. We'll try to be back in 10, 15 minutes, give everybody a chance to use the restroom, get the blood flowing, walk around, stand up, those sorts of things, and we'll get back to it with our next witness as soon as we can after that. And while the jury is out, I'll just remind you again of the admonition. In the meantime, don't talk about the case up to this point. I thank you. Please be seated. The jury has left the courtroom at this time. Did anyone need to place anything on the record before we take a break ourselves?
From the bench conference, is the record clear on what questions were and were not asked, or do we need to supplement the record on that issue?
I believe so. If there's something specific that you have concerns about, you're welcome to make a record on it.
I don't have any concerns.
Okay.
Nothing from us, Your Honor.
All right. We'll try to be back in 10, 15 minutes. Record, and the court will note the presence of both counsel for the state and the case agent, as well as defense counsel and Mr. Mendoza-Keel. The jury should be ready, and I've informed them that we're ready to proceed, and I believe that Erk should be bringing them this way.
I had something I wanted to put on the record.
Okay, go ahead.
Pause the jury. Your Honor, the state believes the defense has opened the door to the defendant's criminal history. There were several questions from defense counsel and from the jury about basically why officers chose to make a custodial arrest rather than write a citation. And I believe if Deputy Willis testifies about this issue, his honest response is going to be, I looked up this defendant in their system on call before arriving and saw his prior criminal history, which is extensive and serious. And that was a factor in Deputy Willis's mind in choosing to make a custodial arrest. So the state does believe the defense has opened the door to this issue about introduction of the defendant's prior criminal history. And we'd move for a ruling that such testimony be admissible.
All right, thank you. Mr. Hartmann-Shawn.
Your Honor, I think it's very established that it's highly prejudicial to admit a defendant's priors, or especially allegations of priors here. What is put into Deputy Willis' notes that he had contacts with law enforcement, arrests, nothing even about convictions. So we'd be going beyond even bringing in unrelevant convictions. We'd be bringing in, or prejudicial prior convictions. We'd be bringing in just allegations of prior offenses. I didn't ask the Corporal Knight, and I have no plans to ask Officer Willis about if, he was aware of any prior violent history or anything like that. I asked him, if on the scene there was something that caused him to move towards arrest. I don't believe, and also so far my only question about that has been towards Corporal Knight, who put nothing in his notes about that. So I just don't see at this point how I've opened the door to them asking Officer Willis about his understanding of prior law enforcement contacts with the defendant.
All right, thank you. Anything further from the state?
Yeah, so Deputy Willis at the time was aware of felony convictions, the same felony convictions the state has given notice of previously in this case, and that he had been to prison for significant prison periods recently. These several felonies were all within, I think, 5 or 6 or 7 years preceding the date of the offense, not including the prison time. So it absolutely is relevant to the issue of why the police, the state, decided to make a custodial arrest in this case, an issue the defense has absolutely opened the door to of why the police chose to make that arrest.
All right, at this time, the court's going to find that the defense has not yet opened the door. The court believes it's a very fine line with full understanding of the circumstances at this point. At this point, the officer that testified, as the testimony was coming out, frankly, it was confusing to me why this officer, Officer Knight, was being asked about this when clearly he wasn't the officer that made that decision. Just in watching the video at the time of the arrest, the court could see that it was Deputy Willis that made the decision, not Corporal Knight that made the decision at that time. Understanding that it was Deputy Willis that made that decision and indicated to the defendant that he was under arrest and would have been taking all of that into consideration, the court, if that question is asked again of this witness, at that point the court's going to see this very differently, as that would be from the court's perspective opening it up as this is the person who actually made that decision and took that into consideration. At this point, I think that the prejudice that would be brought on by allowing that at this stage outweighs, it also factors into the court's determination. But if Deputy Willis is asked those questions and he's the one that actually is making the decision to effect the arrest, the court's likely to see it very differently. But at this point, the court's ruling that the door is not yet open. And with that, the jurors are going to come in. Thank you. Please be seated. At this time, the court will note the presence of the jury. Welcome back, and I hope everyone had a good chance to do anything that you needed to do during our break. I apologize, it was a little longer than I said it was going to be, but that happens sometimes. At this time, the state may proceed with its next witness.
Thank you, Your Honor. The state calls Deputy Jeff Willis to the stand.
All right, thank you. And if you'll come and be sworn, Deputy Willis.
Solemnly swear under the penalty of perjury, the testimony you are about to give is the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, I know that you've been here through all the other witnesses up to this point, Deputy Willis, so you know how everything works in terms of the microphones and everything. So at this point, if you'll just state your full name for the record.
Good morning. My name's Deputy Jeffrey Willis.
And if you'll spell your last name for us.
Willis.
And you may proceed with your direct examination, Mr. Kent.
Thank you, Your Honor. Deputy Willis, could you please introduce yourself to the jury?
Good morning again. My name is Deputy Willis. Actually, it's Corporal Willis now. I work for the Coconino County Sheriff's Office.
How long have you worked there?
I was hired back in 2016. I attended NORDA, that's the Northern Arizona Regional Training Academy in Prescott, where I obtained my post certification and my understanding and application of Arizona revised statutes.
So you said you went to a police academy. What year was that?
2016.
Is the Coconino County Sheriff's Office the only place you've worked as a peace officer?
It is.
What training or experience, what training have you had, if any, since going to the police academy?
I've had the privilege of being a field training officer and a taser instructor, not only for our agency, but also for our local academy here.
Thank you. I want to turn to April 22nd, 2025. Were you involved in the incident that day?
I was.
Where were you working that day?
I was working at the Williams office.
Patrol division?
Patrol.
And how did you become involved in this case?
We were at the office, and one other deputy, Deputy Garcia, had taken the original call. It was on speakerphone. He was on desk duty, but we overheard the entire call, At that time, I advised him, I'll take the call, and I started heading to KEW.
And KEW, what's that?
That's Kaibab Estates West. It's just north of Ash Fork.
Okay. And so this area you're responding to, that's within Coconino County?
It is.
Were you aware of what kind of, what was reported that you were responding to?
It was a reported assault.
So where did you go first when you arrived in Kaibab Estates?
I went to go meet with the reporting party, Mr. Leventhal. I met him at his address.
Did you interview him?
I did.
After interviewing Mr. Leventhal, what were the next steps of your investigation?
After that interview, I made my way towards Mr. Keel's address.
And how did you know where to go?
They gave me the address. Mr. Leventhal did.
Okay. So did you go to that address?
I did.
And describe arriving on scene there.
Okay, so I was in my Mark Patrol unit. Deputy or Corporal Knight was with me. When we got on scene, I called dispatch and let him know. I saw an individual matching Mr. Keel's description. He was sitting outside of his property, and he was putting soil in sandbags.
You said you and Corporal Knight, how many police vehicles are we talking about?
Two, myself and Corporal Knight has his own.
Okay. So did you both get out to talk to the defendant?
We did.
How long were you in that yard talking to the defendant that day?
From start to finish, approximately 5 minutes.
And do you see the defendant here in the courtroom today? Sorry, excuse me. Do you see, did you identify the person you were talking to in the yard that day?
I did.
Who?
It was Mr. Francis Mendoza-Keel.
Do you see him here in the courtroom today?
I see him sitting over there.
Thank you.
Your Honor, objection to identification. I don't think we heard any description or.
The court hasn't been asked to have the record reflect identification at this point, so not at this point.
Could you describe an article of clothing the defendant, Mr. Keel's wearing?
Yes, Mr. Keel is wearing a black suit, a white shirt, and a blue tie.
Thank you. The record reflect the witnesses identified the defendant.
Any objection?
No objection.
And the record will reflect the identification of the defendant by the witness.
So during these minutes that you're in the yard, what's happening at that point?
So I contacted Mr. Keel, and I asked him if he could tell me what had occurred earlier between himself and Mr. Rosenthal. His immediate reply was, "Who's asking?" And I said, "Deputy Willis with the Sheriff's Office," and I pointed to my badge.
So, sorry, you said Mr. Rosenthal. Is that the correct name?
Yes, it is. I'm sorry.
Okay. So you identified yourself as law enforcement?
I did.
Okay. Did you ask the defendant about what had happened earlier that day?
I did. I asked him if he could tell me what had occurred earlier.
I'm sorry, there was an objection, but I couldn't hear
Just
it.
leading, Your Honor.
I'm going to overrule it. Go ahead.
So the question is, did you ask the defendant about what had occurred earlier that day?
I did.
What was the response to that?
Again, he said he was asking. I identified myself, and I said, "Can you tell me what happened?" He's like, "You tell me."
Did he acknowledge at any point that there was an altercation with Mr. Leventhal?
At that point, no.
At some point, did he?
Yes, he did.
How so?
After he said, "You tell me," I told him, "Did you hit Mr. Leventhal in the back of his head?" And he said, "No, I just bumped off his glasses," acknowledging that he had assaulted Mr. Leventhal.
What did you do after that?
After he said that, he started ranting about how Mr. Leventhal owed him money for something else. He went on talking about that. After he stopped, I said, okay, do you want to expand to him a little bit more about what happened earlier? And it's at that point that he said, I'm not going to say anything more.
What happened after that?
Based on what he had told me before, how he did in fact assault the victim, I moved to his position. I said, hey, you're under arrest. And then we got into a fight.
You say we got into a fight. How did this start?
So I approached Mr. Keel and I said, he's under arrest. I reached to grab his wrist. He pulled away and said no. And that's when it got physical. And I attempted to, we started grappling. Mr. Keel is very strong. He had a good solid base. Couldn't take him to the ground. During that skirmish, I felt him hit me on the left side of my head. And then shortly after, and it happened really fast, shortly after I felt his arm going around my head, which would be a headlock, and that is as a law enforcement officer, it's a horrible position to be in.
And let me just slow you down. You said grappling and then ending up in a headlock. What are your concerns in a situation like this?
The main thing is my firearm on my right hip, my taser, which is on my chest, and then also my OC spray, my pepper spray.
You said concern. What is your concern specifically?
Well, when we're grappling like that, I cannot see his hands. He's already indicated to me he wants to fight. So trying to protect my gun and make sure he doesn't pull it out, or my taser, it could easily turn deadly.
Do you know roughly how long this fight lasted?
30 seconds to a minute. It happened really fast.
I think you said you were hit on the cheek. Is that what you said?
On the side of my head.
Okay. Did he connect on any other strikes against you?
That's the only one I can remember.
But in addition, you said something about a headlock.
Yes.
Were there any pushing, shoving, kicks, spitting, anything else that he contacted you?
The whole time we were intertwined, as you've seen in the video. It happened really fast. So no.
Gotcha. Were you able to subdue the defendant?
So while we were grappling, I think you can hear in the video, I was trying to tell Corporal Knight, taser, to try and subdue him. He obviously didn't hear. It's at that point that Corporal Knight came in to assist.
And were you able to separate away from the fight?
So when Corporal Knight got involved, Mr. Keel took his focus off me. It's at that moment that I saw a second to break free, which I did, and I actually ended up on the ground. That's where I scraped my left elbow. But after that happened, there was a clear shot. I saw Mr. Keel's back to me, and that's when I deployed my taser.
We're going to get to that, but you said something about scraping your left elbow. Is that correct?
Correct.
How did that scrape happen?
I don't know if I was thrown off or swung off when Mr. Keel was starting to fight with Corporal Knight.
Was that a result of hitting the ground or from the defendant hitting you?
As a result of being thrown onto the ground.
Thank you. So back to the taser. Why did you feel like you needed to deploy your taser?
Okay, being a taser instructor, that played into it, but the likelihood of me joining the fight, the probability of all of us getting hurt or someone getting shot was exponential. So I found it prudent. The safer way would just be to tase him. It's instantaneous, and we could subdue him that way.
And you, after deploying the taser, were you able to subdue him and gain compliance?
Yes.
Oh, do I want to play the video? I'm going to play what's previously been admitted, State's Exhibit 2, and I have some questions to ask you about that. Actually, before I start, did you have a body camera during this incident?
I did.
And when did your camera start recording?
When it started recording right after the altercation.
Okay. When does your taser have any interaction with your body camera?
Yes. So the way our body cameras work is they're always on and on standby. They're turned on a couple different ways. Either when you're in your patrol car and you turn on your sirens, it'll automatically be activated. If you unlock your gun rack, or if you're on foot and you switch on your taser, it'll automatically turn on.
Was your body camera rolling from the moment you stepped out of the vehicle at Mr. Mendoza-Keel's house?
No, it was not.
And in this case, was it the drawing of the taser that began the recording? And Corporal Knight said something about 30 seconds rolling. Can you explain that a little more?
Yeah, so as Corporal Knight indicated, when your body camera is on, it is continuously has a loop. So as soon as it's activated, there's a 30-second buffer where it starts recording before it's activated. And that first 30 seconds, it's not recorded, but it's rolling.
And is there audio during those first 30 seconds?
There is no audio.
Okay. I'm going to publish State's Exhibit 2 if... Shouldn't it come out? One moment. Oh, right. Thank you. Is this your body camera we're watching?
It is.
I don't have any further questions.
Thank you. Cross-examination?
Thank you, Your Honor. Corporal Willis, thanks so much for being here today. So as we've discussed, as you guys were just discussing, when these body-worn cameras get turned on, and I've viewed hundreds of these, there's this 30-second delay, and then there's sort of a beep, and then we hear the audio come on the recording. Is that correct?
That's correct.
As you just stated, your body-worn camera was not on when you arrived on scene. Is that correct?
That's correct.
And in fact, it didn't activate until your taser was activated during the skirmish. Is that correct?
Yes.
Why didn't you activate your body-worn camera when you arrived on scene?
So my body camera was on when I was interviewing the victim. As soon as I got into my vehicle, I put it on pause. And I remember I was talking with Corporal Knight. When we got on scene, I pushed the button. I thought it was activated. It obviously wasn't.
So it was your intent to activate the body worn camera?
Always, yeah, it's policy.
And is it fair to say then the only sort of independent or the only account you really have of that initial discussion between you and Mr. Keel that you were just describing would be your account, and then if Mr. Keel were to testify during this trial, his account, is that correct?
That's correct.
After the initial conversation you described that we were just talking about, Francis then at that point cut off further basically input on the discussion and wanted to discontinue speaking with you, is that correct?
After he had stated that he had hit the victim, after he said that, he said, did you want to answer any other questions?
Okay. And did you give an opportunity to continue speaking voluntarily over at the station, maybe with counsel present?
Objection,
No.
Your Honor. Relevancy.
Could I have the parties approach? I apologize. I missed the question I was writing down you from the previous answer.
Yeah, so this is the defense, Daniel Hartmann-Strawn. I'm sorry, I've been apparently speaking too fast, so I'm going to slow down. My question was just as to whether the opportunity was afforded to Francis to go to the station to voluntarily speak with officers, potentially with counsel present. Okay.
The objection is relevancy. It's not relevant to whether the defendant committed the charged acts here. In addition, as to what I raised before this witness testified, I believe that is opening the door to testimony as to why he chose to make a custodial arrest instead of to make other decisions.
I'm going to tell you, Mr. Hartman-Strawn, if you ask that question, I'm going to consider you've opened the door to allowing an officer to tell you why he didn't give him that opportunity, which is going to be all about your client's criminal history and his decisions beforehand. So I'm going to leave that up to you, whether you ask that question, but I just want to be upfront. If you ask that question, I think you've done exactly what the state's put you on notice of, and you've opened the door to him explaining why he wasn't given that opportunity. It's only the natural follow-up that's going to come from that question. So you can either withdraw the question. I'm going to overrule the objection. Either you withdraw that question or you proceed understanding that you're opening the door to your client's criminal history coming in at that point. And that being that I'm not allowed the state, at least on redirect, to get into that and explain why that opportunity didn't happen. You can't just ask that question and leave that hanging in the air without them having the opportunity to have the officer explain why.
This is the defense, Daniel Hartmann-Strawn. Your Honor, I totally understand that reasoning. I think I was trying to evoke more sort of, generally whether they would allow some kind of, but I totally understand. I accept the court's reasoning. At this point, I'll withdraw my question.
Okay. Just for the court's position is you just create an inference by that, asking that question, and what answer you might get that the state would absolutely have the opportunity to explain through redirect.
So the other problem here is I was a little slow in making this objection, and the witness already responded no. So if that's going to be stricken from the record and the question withdrawn, I think there needs to be a clear record of that. Otherwise, I think the door is already open.
Okay. The court is going to overrule the objection, but I understand that the question is withdrawn and the court is going to order that the previous answer and question asked are both stricken from the record, and the jury is not to consider it for any purpose. You may proceed, Mr. Hartmann-Strawn.
Thank you, Your Honor. Just broadly, Officer Willis, based on your training experience, is it permissible for a suspect legally to decline to answer further questions when you're questioning them?
It is.
And final question here for you. Did you inform Francis of his charges prior to moving to arrest him?
No.
Objection.
I'm sorry.
Can we approach?
You may approach. I'm sorry. I barely heard the objections. When you have one, just say it out loud. But what was the question and then the basis for the objection?
Yeah, so this is Daniel Hartman-Strawn. The question was whether he informed Francis of his charges before moving to arrest him.
This is Kevin for the state. The objection is relevancy. There's no requirement of that. It doesn't make any fact in dispute more or less likely. I believe the defendant's rebuttal is going to say this is an element of 13409, which the state has made very clear its position that that is not at all applicable or relevant in this case. Further, there's no requirement under any law in Arizona that a defendant need to be informed of why they're under arrest at the time of arrest. So the state does object.
All right. I'll allow the question. So the objection is overruled. The objection is overruled. Go ahead.
And I can rephrase that question just for you. So just the question is, did you inform Francis of of his charges before you moved to arrest him? I believe your answer was no. Is that correct?
That's correct.
No further questions.
And redirect.
Thank you, Your Honor. Deputy Willis, is there any policy or law that you're aware of that requires you to inform a suspect of the charges they're being arrested for at the time that you place them under arrest?
No, sir.
No further questions.
All right, thank you. And do we have questions from the jury? All right, I'll have the attorneys approach. All right. The first question is two parts. It says, what did speaker call say? It's not very clear. I think that's referencing the 911 call. Or what did speaker call say is what it says.
No objection. Kevin Kent, no objection.
This is Daniel Hartman-Strawn. I'd object. It's not clear what the question is really asking. Therefore, it's impossible to determine relevancy. Also, this officer said he overheard some of the call, but he was not the officer receiving the 911 call, so it might also be outside the scope of what he actually knows and can testify to. But primarily, I don't think it's clear what the question is. So I don't think we can even determine relevancy.
I think the question is unclear. I also think it would clearly be hearsay on the part of what came through. Very likely, I have no idea I don't know exactly what the question is referencing. Based on my assumption, it's regarding the 911 call that the witnesses testified he overheard, and I believe that was Mr. Leventhal that made the call.
I understand if the court doesn't want to ask the question, I would like to ask my own follow-up. I don't plan to get into the details of the 911 call. I assume his answer is going to be something to the extent of it was reporting an assault. But 911 calls are generally non-testimonial, not subject to confrontation clause or hearsay. So I don't think there's a legal basis to prevent the state from asking what was the general gist of the 911 call on the speakerphone you heard.
This isn't just playing the 911 call. This is this person here testifying as to what was on it to the best of their recollection. It's not the same thing as you're moving to play the 911 call for the jury to hear what came through. This would be very different from the court's perspective. It's another rung of hearsay, essentially, if the court were to permit it. So the court's not going to. Well, let me go into the second portion. Then it says, what did Mr. Leventhal say? For that, I think that they're asking, what did he say during, I would think that that's in reference to the interview that he conducted with him, but it doesn't specify that, so it really could come back to both the 911 call that he overheard, or it could be related to the interview that he had with Mr. Leventhal.
I don't have an objection to the question. Kevin Kent.
This is Daniel Hartmanstrong for the defense. I'd have an objection to the question being asked as to what he heard about the 911 call for exactly the reasons that were just discussed with the prior question. However, I'd have no issue with the state on its own follow-up asking Corporal Willis as to what Howard Leventhal told him when he interviewed him.
I think both questions are problematic and hearsay and without specific specificity, and the court's not going to ask either of those. So there's nothing to follow up on as to either of those at this time. The second question is, did you go in with the intention to arrest because of what Mr. Leventhal said happened?
No, Kevin Kent, no objection.
I would only object if the court feels that that opens the door to, the officer testifying about his understanding about his prior law enforcement contacts and possible convictions. But
If it does not.
If it does not.
The state renews its position that, and I understand the court's already ruled to the contrary, that the door has already been opened by defense counsel's prior questions. Clearly, the jury is interested in this issue. We've now had 2 juror questions on this issue. I think the defense previously did this without realizing what they were opening the door to, but the state renews its position that it should be able to get into arrest decisions, and including his prior criminal history.
And the court doesn't think that you can answer question 2 without potentially having the officer, if you were truthfully answering the question, he would be answering both because of what Mr. Leventhal said and because of his knowledge of the defendant. The court still is ruling that the door hasn't been opened. I'm not going to ask the question because I think that it would very likely compel the officer to answer as to both of those factors, as they both were at play, as I understand it.
Sorry, I don't understand the legal basis. Is it the court thinks this would be hearsay, or it's not relevant? Is that the court's ruling here? I get the consequence, but I don't understand the legal theory behind the decision not to ask that question.
It invites the officer to talk about the defendant's criminal background, which
so it's a 403
certainly,
issue? Okay.
Yeah. So that alone is enough for the court not to ask that question. Third, it also potentially invites hearsay and other things about what Mr. Leventhal said. My concern is regarding criminal history, first and foremost, but also secondarily the other aspect. Third, what was the impetus for you to approach Francis to arrest him?
Your Honor, I'd object to this question just for the same reasons. I think it's going to invite him to get into that prejudicial content.
The state has the same position as the previous 3 times this essential issue has come up.
And Your Honor, can I sorry, this is Dana Harmonsor for the defense. I really appreciate the state renewing their complaint again and again. However, the court already ruled on this. And so the court said very clearly that the prior officer had no knowledge of these priors, had no understanding of them. I just wanted to
belabor the point. Regarding the question, what was the impetus for you to approach Francis to arrest him? You have no objection, Mr. Kerr, correct? And the state, the defense is concerned that that question is going to raise the issue about his criminal history.
Exactly, Your Honor, for the exact same reasons that I appreciate the state raising, that, it would have factored into his decision-making about these prior arrests, prior law enforcement contacts. I didn't see anything about prior convictions, but he definitely mentions prior arrests and law enforcement contacts. And that in and of itself, as we discussed prior to beginning this afternoon, would be prejudicial in our eyes.
The question from my perspective is about, his decision to physically approach, walk towards the defendant to start the process of effecting the arrest. I don't read the question as like the decision to arrest him, but rather about the physical step forward. Maybe I'm off on that. Maybe that isn't how the question will be taken by the witness. So I understand that the state thinks the door is open. I've ruled that it hasn't. That's done for the time being at least. So I want perspective from the attorneys as to the risk of the question in terms of him getting into something that I've ruled that it can't possibly cause a mistrial. Do the parties see the question differently than I do?
This is the defense, Daniel Hardman Strawn. I have no objection to the question being answered so long as, as long as the answer is cabined to exactly what was just described by the court. Of course,
can't do.
Right. I mean, so that's the issue, is that if this wades into his, prior contacts with law enforcement stuff, then I'm potentially going to be moving for a mistrial. So.
All I think I can do at this point is move for the court to reconsider its prior decision. But I think, this is now not accounting the opening statement from the defense and the cross-examination of Corporal Knight. There's now been 3 juror questions that basically are getting at this same issue of what was in your mind when you made these arrest decisions, including, decision to physically approach him to arrest him. And I think we've already crossed that bridge, so we'll leave it there.
Well, I've already ruled on that. You're still not answering my question. With that, I'm not going to answer the question. You have some concerns about the risk of asking that. Fourth, why didn't we see video of Mr. Leventhal on your body cam?
The state's position, we chose not to play body camera interview with Leventhal because we think it's hearsay, and we had Mr. Leventhal testify for that reason. So the state does object to the question. It gets into an area that's I think would be improper.
Your Honor, we have no objection, but I would note that kind of the irony here that the state is now objecting for the reason I objected to the other thing. So, I would just say broadly, the jury can ask questions that they're not entitled to know the answers to because of the rules of evidence and all these things. So that's exactly what his position is here. That was my position on the last question. So.
I'm not going to ask you that. I know that you would just say there is a body cam of that interview. It just hasn't been provided to you. And then that's not helpful to the jury in making any of its determination here. So I'm not going to ask it. Okay, next. I don't know why this juror has these little scraps of paper instead of sheets. But the question is there a policy written in which an officer needs to double check body camera is on before conducting an interview?
An object is asked and answered.
I have no problem with the question. I think it just gets the officer's training and experience, which he's well suited to answer.
All right. I'll ask it. I'm not going to suppress the question based on ask and answer. The jurors, just the same way that the two of you ask questions and do cross-examination, they're kind of like another step of that. If they have a question that's they want confinement on, or they didn't hear you ask or something, I'll ask it. So the next question is, I think it's a follow-up. What happens if the body camera is not turned on, question mark, according to the policy, question mark?
Same object, state, Kevin Kemp for the state. We object on relevancy grounds. I don't think body camera policy has any, I think the question about why it wasn't on is fair. And the question of what the policy on having on, what happens in that case, it's just not relevant to deciding the essential elements of the charges here.
This is Daniel Hartman-Strong for the defense. Yeah, it's a little unclear, I think, to me what the jurors getting at. Potentially they're getting at, is there some sort of, indication in the evidence that he wasn't recorded or something like that, but it's a little unclear to me. I think this could be, I have no objection. I think this could be asked just based on the officer's training experience. And I think it is relevant to, the evidence that the jury's seeing or not seeing.
I'm not positive, but I think the officer, the juror's trying to ask if there are, consequences or specific things that are supposed to happen. Perhaps it's kind of like delving into whether or not it's proper evidence or something like that. Obviously, that's my job, not theirs. Their job is to make the determination of the facts and apply those to the law. What comes in or doesn't come in, that's my job. So I don't think it's useful in any way, and so I'm not going to ask that. I don't think it's relevant to their determinations. I am going to ask just the first question regarding whether there's a written policy. That's already, as the state pointed out, there's already been questions about that, so I'll ask that. So out of all of those, that's the only thing I'm actually going to ask.
Yeah.
All right, and I am going to ask a question of the officer. I just want to take a moment just to remind the jury that whether I ask questions or don't ask questions isn't a reflection on whether or not they're good questions or bad questions or otherwise. Just as I stated in the preliminary instructions, I have to apply specific rules of evidence to those the same way that I would if the attorneys were asking them. So with that, I'm not trying to stifle the questions keep coming from the jury. The question I'm going to ask you, Deputy, is there a policy written in which an officer needs to double check body camera is on before conducting an interview?
There is policy. It doesn't specifically say that you have to double check, but the policy says anytime you're interacting with the public, it shall be on.
All right, and is there any follow-up from the state on that issue?
Yes, Your Honor. Your body camera was on when you initially arrived to interview Mr. Leventhal.
That's correct.
Okay. And you said something about pausing it. Is that what happened?
Yes, I paused it.
So when you arrived at Mr. Mendoza-Keel's property, did you forget to turn it off of pause?
I went to activate it. I thought it was activated. I guess I didn't push the button hard enough.
Nothing further.
All right. Anything from the defense, Mr. Hartman-Strong?
No further questions, Your Honor.
All right. Just double checking that we don't have any further questions from the jury. And we don't. May this witness step down?
Yes, Your Honor.
All right. You're excused at this time. I know you're going to be with us. And the state may call its next witness.
Your Honor, this time the state rests.
Thank you. And with that, I think now would be a good time to go ahead and break early for the lunch break. We'll come back. I'd like the jury to come back. I'm going to give you an extended lunch at this time and have you come back at 1:30. And we'll see the parties or the jurors back at 1:30 and proceed with the case at that time. Thank you. Please be seated. All right, and at this time, the record will just reflect that the jury is not present. And at this time, the state has rested. I didn't want to jump right into the defense possibly presenting a case or not presenting a case without at least excusing them for some minutes. Being so close to noon, I decided to let them go for lunch early and address that with defense counsel. So I want to address the defendant and whether or not he chooses to testify or not as well. Can you speak to whether or not the defense was intending to present a case, Mr. Hartmann-Strawn?
Yes, Your Honor, we plan to present a case and we plan to call the defendant.
Okay, very well. And Mr. Mendoza-Keel, with that in mind, I just want to confirm with you that it's your intention to testify in the case. It's really important for you to understand that the decision to testify or not is entirely yours. No one makes that decision except you. You, of course, take into account any advice that you have from your attorney, but ultimately that decision rests with you. There's only a handful of decisions when you're represented by counsel that are actually yours in a criminal case like this. This is one of those that you have absolute control over. And I just want to confirm that it's your desire to testify in the case.
Yes.
Okay. You still could change your mind, just so you know. I just want to make a clear record of that now, and then when the time comes after lunch, the jury will have the opportunity to hear from you if you choose to. But if you change your mind, you can do that still as well. But we've made it. I wanted to make a clear record that you understand that decision is totally yours. Do you have any questions you wanted to ask me?
No.
Okay, very well then. With that, next I want to get the instructions as prepared as I can before the jury comes back and before we try to address the issue regarding the interplay between 13-404 and 409. So what I also want to look at the case that the state provided the citation for before our previous break, and then also look at a couple of cases that the court, I briefly was researching that issue over our last break as well. So what I'd like to do is go ahead and break for lunch and work both on the instructions in that issue until 1 o'clock. And I'd like to return at 1 o'clock to start addressing both of those. Is that workable for the attorneys?
1 o'clock is fine, Your Honor. I just want to confirm there's no motions from the defense at this time, or if there are, if we're going to take those up now or later.
Oh, did you have a Rule 20 motion based
Your
on
Honor.
close?
Yeah, and I have a script for that. Let's get that pulled up.
And thank you for that, Mr. Kennedy.
Your Honor, the defense would move for a judgment of acquittal pursuant to Arizona Rule of Criminal Procedure 20A. The defendant is entitled to a judgment of acquittal when no reasonable jury could find that the defendant is guilty of the crimes that he has been charged with. Even in viewing the evidence in the light most favorable to the state, no reasonable juror could find that there is substantial evidence to support a conviction. Here, Your Honor, we would find that there's not been substantial evidence to show that Mr. Mendoza-Keel did not act with justification in self-defense when he resisted the unlawful arrest by Corporal Knight and Officer Willis, or Deputy Willis, excuse me. We'd also argue that there's not been substantial evidence provided to prove that Mr. Mendoza-Keel assaulted Howard Leventhal. We have heard testimonial evidence from Mr. Leventhal. We are going to hear from Mr. Mendoza-Keel as to that interaction, but there's no prior recording of it. We heard no testimony as to visible injuries to Mr. Leventhal, and we heard conflicting accounts of whether it was a closed-fist strike that brushed his head or whether it was an open-handed strike that hit him in the back of the head or whether his glasses were struck. In any case, Your Honor, that changing information, I think, calls into question whether or not there's enough evidence to support a conviction for misdemeanor assault against Mr. Leventhal. Based on the evidence provided, no reasonable juror could find the defendant guilty of the charges, and we therefore ask the court to grant the defense's motion for a judgment of acquittal. Thank you.
All right, thank you. Does the state wish to be heard?
Yes, Your Honor. Your Honor, the state opposes the motion, asks that the court decline it. We have heard overwhelming evidence in this case of the defendant's guilt. There's testimony from 2 officers and 1 civilian, all who testified consistently that the defendant struck each of them that day. Mr. Leventhal also testified that he was in fear. He was scared of the defendant as he approached his car, shook his car, reached in and hit him. That goes to the disorderly conduct count. Furthermore, there's incontrovertible video proof that the defendant struck these officers, and not just struck them, fought with them in a very violent way, so violent that he had to be tased to end the altercation. So violent that the defendant had to be tased for the altercation to come to a close. This evidence is sufficient for a jury to find guilt. We would ask the court to deny the motion. Thank you.
All right, thank you. Anything further, Mr. Hartmann?
No, Your Honor.
All right, the court, in making a ruling on Rule 20 motion for acquittal, has to determine whether or not substantial evidence has been provided to support conviction. Specifically, substantial evidence is proof that reasonable persons could accept as adequate to support the conclusion of the defendant's guilt beyond a reasonable doubt. And the court also notes that there's a complementary interpretation that substantial evidence means evidence that would convince an unprejudiced thinking mind of the truth of the fact to which the evidence is presented. When making that determination, the court is required to make all inferences against the defendant, and the court notes the credibility of witnesses exclusively left in the province of the jury. So the court has to take the testimony at its face value and not put its own determination of credibility on it. The court notes in the case that as to the 2 misdemeanor counts involving Mr. Leventhal, that Mr. Leventhal has testified under oath here, easily establishing the elements for an assault, whether the hand is open, closed, or merely a touch. The court believes that there's substantial evidence of an assault and disorderly conduct, both based upon the actions of the defendant as testified to by Mr. Leventhal. So the court easily makes that determination for those 2 misdemeanor counts. As to the 2 felony counts, the court agrees that there's been tremendous evidence presented, both in the form of the under oath testimony of the 2 officers who were present, and the very very obvious videos that were presented and admitted in the case up to this point that depict the entire incident from multiple vantage points from both officers' respective body cams. The court believes that there's far more than simply substantial evidence that's been presented up to this point. So at this point, the court denies the motion for acquittal. With that, let's be prepared to come back at 1 o'clock. Okay, thank you. All right, welcome back. We're on the record in State of Arizona versus Francis Mendoza-Keel, CR 2025-00513. The court will note that the jury is not present. Both counsel for the state and the case agent are present, as well as defense counsel and the defendant. And at this time, the court, I have apologize that I wasn't ready quite at 1 o'clock. To be candid, I've been working since we broke, and I'm still not entirely ready for everything at this point. I did get the jury instructions as near to ready as I could, I think, without first hearing from the parties an argument regarding justification and other requested instructions. And then also the court believes it may be necessary to hear the defendant's testimony before making some of those determinations also. Is it still the intention of Mr. Mendoza-Keel to testify as soon as we have the jury present?
It is, Your Honor.
Okay, and is that still correct, Mr. Mendoza-Keel?
Yes.
All right. So with that, it affects some of the court's determinations potentially. And so what I'd like to do is I've given the parties a copy of the instructions that I've got prepared up to this point. What I'd like to do, many of those are the instructions that you both asked for. A few of them are instructions that I think should have been included that weren't. And I'd like to go through those, the kind of softball ones that are simple, so that we can have that taken care of. And then after the presentation of the defense case, then we can conduct the argument regarding further instructions, okay? So did everybody get their copies?
Yes, Your Honor.
Okay, very well. So let's start. Most of these track between the two requests from each. I've tried to make note in those places where they're different. Does anybody have any objection, of course, to juror duties, page 1?
No, Your Honor.
No objection.
And just to be clear, these are all just the standard instructions. I haven't done anything creative with any of these. Page 2, regarding the defendant being charged with a crime.
No objection from the state.
No objection.
And the ones that are just to be clear, I already have taken the headings and everything off and just have the clean instructions for those instructions that the two of you both asked for. And then next, the law does not require the defendant to prove evidence on page 3.
No objection.
No objection.
We'll do that. Next, state's burden, page 4. That was the 4A instruction. Each of you asked for 4A rather than 4B.
No objection.
No objection.
Next, page 5, you must decide whether the defendant's guilty or not guilty.
No objection.
No objection.
Page 6, you are to determine the facts.
No objection.
No objection.
Page 7, the state must prove guilt beyond a reasonable doubt based on the evidence.
No objection.
No objection.
Page 8, in their opening statements and closing arguments.
No objection.
No objection.
Page 9, this was one that I added. Neither of you requested it. Standard Criminal 13 redacted exhibits. And it's just the standard instruction regarding some exhibits being redacted. I felt that this was probably appropriate given that we have videos that cut off, and based upon some of the testimony that the officers provided regarding how the body cam worked, I thought that that would possibly create some question in the jurors' minds as to, well, where's the rest of it? So I thought that this instruction would be appropriate, so I wanted both of you to consider it.
Your Honor, the state doesn't, I guess we'd object to the inclusion of this instruction. I understand what this court is saying about body cameras not being complete. I can understand what the court is saying about the body cameras not being complete, but I don't think there's any redactions or like black boxes or portions that have been silenced, things of that nature. So I don't believe it's appropriate. I think it could cause confusion by saying some have had portions deleted. I just don't think that's accurate, that any portions have been deleted.
Don't you agree that the the videos are much longer than the portions that were viewed by the jury here in court.
I do, Your Honor. I don't think that's the same as deleted or redacted. So that's my position.
From the defense?
Your Honor, I think taking a clip and removing part of it is the definition of deleting part of that clip. So I think this is a very appropriate instruction, and I have no objection.
Yeah, I agree. I'm going to include that. Page 10, evidence may be direct or circumstantial.
No objection.
No objection.
Page 11, in deciding the facts of the case.
No objection.
No objection.
Page 12, the testimony of a law enforcement officer.
No objection.
No objection.
All right, page 13 it was presented to the court that 18A or 18B would be appropriate. In a case where a defendant has testified, the court's frequently been asked to include both. If you look at 18A in the standard instructions, I don't have it here, but there's an additional bracketed sentence on 18A that typically is included when a defendant does not testify. I believe in addition to what's here, but it would be the court's intention if Mr. Mendoza-Keel testifies that the decision whether he testifies or not to let that choice affect you in any way, can still be provided. But I thought I'd hear from both of you in that.
Assuming the defendant does testify, the state would ask for only 18B to be included?
And Your Honor, I don't think I'd have any objection to only 18B being utilized.
It's always been the defense asking for 18A to be included along with 18B. I've never had an objection from the state when that request has been made. If the defendant isn't asking for 18A to be included at the same time, I won't.
Your Honor, I don't think I'm asking for 18A to be included.
All right, I won't do 18A, so that instruction that's on page 13 that we're looking at won't be included, and I will include the instruction on 18B, which is on page 14. Page 15, neither of you had requested the voluntariness of defendant's statements. I certainly think that that's already appropriate in the case. Frankly, the time of the comprehensive pretrial conference, the parties told the court and the state indicated that they didn't intend that no defendant's statements were anticipated to be used in the case, and we've already heard statements in the case from the defendant. So the voluntariness instruction related to those statements, I think certainly that instruction is already appropriate at this point. What's the state's position?
I don't have an objection to including the instruction.
And no objection, Your Honor.
All right, I will include that on page 15. Standard 21 is on page 16. Assuming Mr. Mendoza-Keel is going to testify, much of the disagreement about opening the door to his prior history and stuff is somewhat moot because he'll be subject to cross-examination and impeachment with his prior convictions as soon as the state comes up. So standard 21, I think, should be included. Do the parties both agree?
Yes, Your Honor.
Yes, Your Honor.
All right, 17 is just this exact same definition of aggravated assault as used in the preliminary instructions. This is obviously an abbreviated version that just tracks the exact language and the information. Any objection?
I don't have an objection. It seems that there might be an extra space between assaulted and was.
I see it, and I'll change that. I think that you're right also. I'd already circled that as well.
Your Honor, just noting that, no objection.
Okay, so I'll get that space out of there. Page 18, the crime of assault requires proof. Again, this is exactly what's in the It was in the preliminary.
No objection.
No objection.
All right. 19, the crime of disorderly conduct.
No objection.
I don't know how it's phrased in the statute. I would ask that person go first before neighborhood or family, assuming that's how the statute is written.
I don't think that's the order it's in the statute. I can look quickly.
You're right. It's neighborhood, family, or person.
And that's exactly how it appears in the, it's the same order that's in the information, not that that's determining.
No objection.
All right.
No objection, Your Honor.
All right. That one on 19 will be provided intentionally with intent to. The definition is provided on page 20.
No objection.
No objection.
Knowingly on page 21.
No objection.
No objection.
Peace officer on page 22.
No objection.
No objection.
All right. And then we have the justification defense. The court would note that the copy that you have there has no limitations on it. Very often parties submit a refined version of that instruction with agreement between the parties as to what's appropriate under the case. At this point, I don't think the parties even agree on the instruction being provided at all. Is that correct, Mr. Kent?
Yes, Your Honor. The state, for reasons stated this morning, the untimely disclosure of this defense, but also that the state does not believe there's even the slightest evidence supporting the inclusion of this instruction.
Right. And I don't want to get into all that argument just yet. I know your position, but I just want to make sure that there wasn't any change of heart, I guess, in that regard. So the same is going to go then for whether or not it would be appropriate to include the 38.81 instruction or the 38.88 instruction. The court will note that the use note in the comments on the justification defense do specifically reference each of those two instructions as potentially being appropriate depending on the facts of the case, and that's contained therein. So the court will make a decision on all of those after we hear from Mr. Mendoza-Keel, because certainly what he has to say could have bearing on the court's decision on all of that. The last instructions on page 27, which is the actual instruction on how the case is to be decided by the jury, their deliberations. Neither of you asked for that one, but obviously it's very important. Any objection?
No objection.
I did change, and I assume you don't object, Mr. Armstrong.
Sorry, I was just finishing reading it, but no objection, Your Honor.
I was going to draw your attention to it. I did try to make sure that it's for 8 jurors, and also the very last paragraph that it would be for 4 forms of verdict. I don't have the forms of verdict in front of me at the moment. I did receive those as submitted by the state. The only issues I wanted to see if we could address on the forms of verdict, just for the, I am going to give that last instruction unless anybody sees any problem with it.
That's fine.
Okay. So on the forms of verdict, I would like to just change those to include in the, it's not the heading, but in the caption, instead of it just simply saying verdict, I would like to say verdict Form 1, verdict Form 2, verdict Form 3, verdict Form 4, I'm sorry, so that each of them is very obvious up in the caption at the top right. If we could just change that, and rather than having the jury write into the verdict form, I would like to change it to just a spot for them to check either guilty or not guilty. Is that agreeable to the parties? Other than that, I'm fine with them.
Yes, Your Honor.
That's fine with the state.
And frankly, I just think it's easier for them to check it, and then they're not, it doesn't leave it on them to use the right wording or verbiage or et cetera. It's a little bit simpler, and then it's very clear. I know in the body of the form, as I recall, it references that it's 4 count 1, 2, 3, 4 already, but I just want to include that in the caption also. Would it be possible for the state to just make those, or someone for the state to make those small modifications and then get them to council?
Yes, Your Honor, I can do that during a break.
Okay. I wasn't necessarily trying to put it on you. I was wondering if you could put it on somebody else in the meantime. But so if we could just make those changes at that point, the court would be happy with the verdict forms. Is there, and did you have any issues with any of that, Mr. Hartman-Strawn?
No, Your Honor.
I may have asked you, I may not have asked you. I didn't mean to neglect that. I haven't heard, I would assume that the jury's back and ready to go. Is there anything else that the parties need to put on the record right now?
Just a clarification, I think it was about 38 and 81, sorry, 38.81 and 38.88. You said something about the comment to some instruction.
It's in the comment to the justification instruction.
So
There's a use comment at the bottom of it in standard, I think it's 4.04.
Okay, I just wasn't sure.
If you look down there, those two are specifically referenced for the court to consider using in cases where the facts deem that appropriate.
Understood. Thank you for the clarification. The only other instruction the state would ask the court to consider is the alternative to 4.04-1, the non-justification for the use of physical force.
And I certainly don't have that, like, I don't know, it seems like it's 1,000 pages form of the Raji's right in front of me. Can you give me the?
Page 61 of the 6th edition, 2022.
Just give me the number of the
It's
standard.
4.04-1.
Okay. So I don't have that in front of me yet. I've made note of it. And before we take up those other issues, I'll get a copy of that in front of me. And if anybody else needs a copy of it, I can get that and we can take that up at the same time. Anything else?
Nothing from the state.
Nothing from us, Your Honor.
All right. Mary, have you heard from the bailiff?
Can I run to the bathroom real quick?
He said they're ready.
Okay. You know what? We need a real quick bathroom break, and in 5 minutes we'll call them in. And if everybody will just be in here in 5 minutes.
Thank you.
Thank you. Please be seated. All right, we're back on the record in State of Arizona versus Francis Mendoza-Keel, CR 2025-00513. The court will just note the presence of both counsel for the state's case agent, Mr. Mendoza-Keel, as well as the defense attorney. And the jury is not present, but we've notified them that we are ready for them. All right, the jury's here.
Everyone in the jury?
All right, thank you. Please be seated. And welcome back to the jury. We are ready to proceed with the defense case. I apologize that we've been keeping you a little extra time, even longer than I had thought. Been working through a number of issues, so apologize for the delay, but we're ready to pick up where we've left off. At this time, I'll turn it over to the defense to present its case.
Your Honor, the defense calls Francis Mendoza-Keel to the stand.
All right, thank you. The clerk will swear you in, Mr. Mendoza-Keel. If you'll raise your right hand.
I will not swear by heaven, nor by earth, nor by Jerusalem, nor by my own head, but on nothing one hair turned white or black. But I will let my yeses be yes, and my noes be no.
So, Mr. Keel, you don't have to swear, but do you affirm to tell the truth, the whole truth, and nothing but the truth? All right. If you'll raise your right hand, I'm just going to have you affirm under oath. Do you affirm to tell the truth, the whole truth, and nothing but the truth? Okay. Very well. That's sufficient. So you can come around and take a seat next to me here.
Your Honor, can we approach?
You may.
Kevin Kent, the defendant appears to have notes in his hands. The state objects to him having any written notes while he's on the stand testifying.
I agree with that. I assume you do, Mr. Hartmanstrong.
Sorry, I can remove those from them.
But you'll just take those from them before you begin, and then I'll turn it over to you, okay? That's fine. You may proceed when you're ready, Mr. Hartmanstrong. Oh, let me just back up. Mr. Mendoza-Keel, you've seen how it works in terms of the chair, the microphone, and you know that they're directional. So if you'll speak right into those, and then if you'll just state your full name for the record.
My name is Francis Cruz Mendoza-Keel.
And if you'll spell your last name for us.
I have two last names. Which one would you like?
Both.
Both of them, okay.
Is it
Mendoza.
hyphenated?
Yes.
Yeah, if you'll give us both.
Mendoza, Mendoza, hyphen Keel.
Thank you very much. And you may proceed at this time.
Thank you, Your Honor. Mr. Keel, can you please introduce yourself again, just briefly to the court?
Yes. My name is Francis Cruz Mendoza-Keel, and I am here to give testimony.
Wonderful, thank you.
Oh, if you
Just
could
pull it towards you.
Perfect. And if you could repeat that last question and answer.
Oh, absolutely. Could you just introduce yourself again for the court?
My name is Francis Cruz Mendoza-Keel, and I'm here to give testimony.
Thank you. So on April 22nd of last year, where were you?
On April 22nd of last year, I was located at 100 West Canyon Road.
And was this a proper, what was located at that property?
There was a shed located at this property.
What was your purpose for being there?
My purpose for being there was to attempt to buy a home for my family, but I was swindled into this.
Okay. Were you renting or owning the property at the time?
At the time, I was renting.
And who were you renting that from?
Howard.
And can you give me the full name of the person you're renting it from?
Yes, Howard Leventhal.
Is that the same Howard Leventhal that's one of the victims in this case?
Yes.
So you rented from Howard, is that correct?
This is correct.
What was the nature of your rental agreement?
The nature of the agreement was to pay $350 a month, but along the lines, I ended up losing my job because my boss at the time had encountered Howard while she was in high school.
Your Honor, object relevance.
Overruled. Go ahead.
My boss at the time had encountered Howard at the time, and some non-profitable things happened between the two, she being female and him being male. So she slowly but surely gave me less hours and caused me to end up forcing myself to quit, because at that point I was working for free. Everything went from 50 hours to 60 hours to 100 hours, not paid. So at that point I said, you know what, there is some bad blood between you guys and I need to move on. So that's when the last 2 months happened, where Howard stated that we entered an agreement to where I would work hours for, rent. And not only hours, but projects.
And were you, in fact, working on those projects and doing that work?
Yes.
As far as you could tell, given the outlines of this agreement as you understood them, were you meeting your responsibilities under that lease agreement that you had kind of modified?
Yes.
Did you and Howard ever have a disagreement about this lease agreement you had?
Yes.
Did you encounter Howard on April 22nd of last year?
Yes.
Did you have any discussion with Howard?
Yes.
What was the nature of that discussion?
The nature of the discussion was him claiming that I did not pay him rent, but I know that Howard is an avid user of concentrates, and as you know, using concentrates of such excess can cause you to have certain memory losses. I tried to reiterate to him that the rent had already been paid and to go look at the road, and not only that, but to look at the firewood stove that was recently installed, which cost me myself $300 out of pocket. So after these things were done, not only was rent paid for that month and the second month, but the third month as well, because of the amount of hours that it took to rebuild a road that was destroyed by a semi-truck no more than a week before the incident.
Okay. So it's fair to say you felt like you were living up to your end of the bargain.
Yes.
When you had this discussion on April 22nd, did anything physical occur between you and Howard?
Before April 22nd?
Sorry, on April 22nd, when
Oh.
you had that discussion.
No, nothing physical happened between us.
Did you ever touch Howard?
No.
When you then were later encountered by law enforcement, later in that day, did law enforcement come out to the property?
Yes.
When law enforcement came out of the property, how did they introduce themselves to you?
When asked, the officer said, "Who do you think?" and pointed right here to his, I assume it was his badge, but I don't have very good eyesight, so it's hard for me to see, and I would have preferred him to identify himself fully and give his badge number, but he did not do that. He just said, "Who do you think?" and pointed right there.
Were you asking for identifying information like that?
Yes, I was.
And it was not provided to you?
It was not provided, no.
Did the officers give you a reason for why they'd come out to the property?
No.
Did you ask them for a reason why they'd come out to the property?
Yes.
Did you ask if you were being charged with anything?
No.
Right, so you didn't ask the officers at any point whether you were being charged with anything?
Objection, asked and
No.
answered.
Sustained.
Did the officers offer up anything that you were being charged with?
No.
Did you ask any questions about the nature of what was being alleged against you?
Yes, I did.
Did you receive any response about that?
I received a response of, and I'm not sure if this is relevant to you guys, but he said that he didn't know what the two elements for probable cause were.
How did you feel given that, response to your question?
I felt that he was not operating under his color of law, but he was operating as a tyrant.
Did you feel that you were ever given an explanation as to why law enforcement was contacting you that day?
No.
What happened after you had been talking with the officers?
What happened after I had been talking to the officers? They said that I was under arrest and they assaulted me.
And again, as the officers moved to arrest you, did they announce any charges or reason for the arrest?
No.
Did you ever request that information as you were being arrested from the officers?
Yes.
During the arrest, did you come into any physical contact with the officers?
Yes.
What was the nature of that physical contact?
Self-defense.
How did you employ self-defense? What measures did you take?
I took 2 steps back, and once the officer made contact, he immediately attempted to throw me on the ground, but my footing was sure, and he was unable to do so. Then that is when Corporal Knight ran in, and he struck me not once, not twice, but 7 times in the face. After the 7th time, I said enough was enough, and I pushed my hand forward, and I tried to distance myself from him because being struck in the face is not pleasant. So after that, I recall letting go of Deputy Willis and jumping towards him, but not in a manner to try and strike him, but to try and push him farther away because he was real close to me, and I was scared. They had 2 guns, they had pepper spray, they had tasers, plenty of voltage to kill somebody, plenty of, mistakes could be made.
If you don't mind, what kind of force was being utilized against you? You had previously described some of it, but just throughout the course of this skirmish.
Physical, unlawful force, and a taser.
Can you get into exactly what kind of strikes might have been used, things like that?
Closed fist strikes to the left side of my face, I believe.
Okay. And I believe you said 7, is that correct?
Yes, if I recall correctly.
As this skirmish went on, did you ever reiterate your desire to know why you were being arrested?
Yes.
At what point did you do that?
After I was taken to the ground.
Do you recall what you said to the officers?
Objection, calls for hearsay.
Yes.
Sustained.
In that moment, did you try to express to officers your concerns about the arrest?
Objection, calls for hearsay.
Yes.
I'll allow that question. And you've already answered it. You may proceed.
Did the officers respond to your request at all?
No.
Did you continue once you were in handcuffs and then transported to jail? Did you at any point pass that request information as to the nature of your arrest?
Objection, relevance.
No.
Sustained.
I'd ask the answer to be struck.
Answer is stricken. Not to be considered by the jury. You may proceed.
As to, this discussion that happened right before you were placed under arrest, did you attempt to engage the officers in a calm discussion?
Yes.
Can you tell me sort of what happened during that discussion?
I was approached by an officer whom I asked to identify himself, and he pointed at his vest area, but did not properly identify himself. I asked him for the reasonable articulatable suspicion and the single articulatable fact, the two elements that are necessary for establishing probable cause for an arrest. Once the officer told me that he did not know what that was, I knew that he was not there to figure out the truth. He was there to just be somebody's goon.
All right, thank you. Is there anything else about the arrest or that day that you feel is important or relevant?
Just the fact that the arrest was unlawful and it fails to meet three
Objection
prongs.
calls for legal conclusion.
Sustained.
Three prongs necessary for.
I'm going to stop you based on the ruling, Mr. Mendoza-Keel, and I'll strike the answer or the partial answer.
All right, no further questions.
All right, thank you. Cross-examination.
Mr. Mendoza-Keel, you're a felon, is that correct?
Yes.
You've been convicted of at least 3 felonies within the last 10 years?
Yes.
Yavapai, Superior Court 2019, is that correct?
Yes.
Yavapai Superior Court 2020, is that correct?
Yes.
Thank you. You said your hours were reduced leading up to this incident. Was that at your prior job? Is that correct?
This is correct.
You also testified that the hours were increasing without pay from 50 to 60 to 100 hours. Is that correct?
Yes.
So how is it your hours were reduced but also increased at the same time?
It was a double whammy. It was like the owner of the restaurant was saying, you are not to be doing business with this guy and you are not to be giving him my money, which I thought was strange because it was my money that I had worked for. So when she had told me about their encounter, it was like an FU to me. It was lowering the hours, but keeping the hours that I did work unpaid.
Thank you. Do you recall you acknowledged there was a physical altercation or a fight with the 2 officers on April 22nd, is that correct?
Yes.
Do you recall making statements during that fight?
Yes.
Do you recall saying, come on, boy, or something like that?
I don't believe it was come on, boy. No.
What was it?
I think it was let's go.
I'm going to play a portion of State's Exhibit 2. I
think you already have the projector assigned to you.
Thank you. A moment. I don't have to tap it. Excuse me. I'm gonna play State's Exhibit 1 actually. Did you hear that just now
Yes.
in the video?
Yes,
What did you say in the video?
I was saying, come on, boy.
Was it, that's it, boy, that's it? Should I play it again?
Play it one more time, please. Yes.
Did you hear that?
That's it, boy. Yes.
So that was you saying, that's it, boy, that's it?
Mm-hmm.
And just so we're crystal clear, you agree that that's you on this video in the orange shirt?
Yes.
Do you recall saying, I like it during the fight?
Yes, I do.
And what were you referring to that you liked?
Being tased.
You liked being tased?
Yes, I know it's a really strange thing, but I enjoy the feeling of electricity in the body.
But you don't enjoy the feeling of being struck?
This is true.
Do you believe the laws of the United States and of Arizona apply to you?
Yes.
Were you working in the yard that day, filling sandbags or something along those lines?
Yes, I was filling sandbags to finish the repair of the damage done by the semi-truck to the road, which was about 40 or 50 feet of damage.
Was that a dirty job?
Very dirty, yes.
You said during your direct examination that the officers used, I believe you said they used unlawful force on you. Is that correct?
Yes.
Is that your testimony?
Yes.
I'm going to wind back to this video, and I'd like you to tell me where you think the force exceeded by law occurs in this video. Can you do that?
Well, it occurs in the first 30 seconds it's bleeped out.
So
I'm trying to establish probable cause for the arrest, which he fails to give.
So the questioning, I'm going to put up, we're looking at questions 15 seconds into State's Exhibit 1. You're standing in the yard, hands on your hips. Deputy Willis is in front of you, that's correct?
Mm-hmm.
And so the audio would be silent. It's the first 30 seconds. Is that your understanding?
Yes.
Okay. And it's your position at this point, unlawful force is being used against you?
Yes.
What about unlawful physical force?
Yes.
Where is the physical force in this picture?
The grappling, the punching, the tasing.
I'm not talking about the rest of the video. This screenshot, 15 seconds paused into State's Exhibit 1. Is there physical force happening at this moment?
No.
Okay, so what I'm trying to get to is, where does the physical force start?
The moment he grabs me. Mind you, without giving me reason as to why he's arresting me.
Non-responsive, move to strike.
Overruled.
If an officer, never mind. I just want to play this part again.
Is there anyone else here with you? No. At this time, we're going to consider arrest.
Did you hear Deputy Willis in this clip just say, at this time, you're going to be placed under arrest?
Yes.
And that's what happened on April 22nd? You heard it then also?
Yes.
Did you comply with the arrest?
No.
I'm going to switch to State's Exhibit 2. So this is 27 seconds into the video. I'm going to play about 5 seconds actually of this portion. But before I do that, do you see legs in the upper left portion of the screen here?
I have a hard time of seeing that distance, but I believe you, yes.
You don't have any dispute that those are your legs we're seeing the back of?
No.
Objection, Your Honor, to continue to show this clip. It's cumulative.
Overruled.
So I'm just going to, and I don't have a way to go frame by frame, but I'm just going to try to slide slowly here. Do you see your legs fly off the ground and your fist go into Corporal Knight's head? Is that what's happening in this portion of the clip?
I do not see my fist in that clip, no.
Let me back up. I'm going to back up to 26 seconds. Do you see shadows in the bottom left of this clip?
Mm-hmm.
Would you agree that the shadow furthest on the left is your torso and your arm outstretched?
Yes.
Objection, Your Honor, calls for speculation as to who's in a shadow.
Overruled.
I've just advanced about a second. Do you see the shadow of your hand open, as in your fingers are extended in that clip?
It's really hard to define that. I'm not sure.
I think it would be acceptable to the court if you need to stand up and get closer to see this better. There's no objection.
Would that be helpful to you, Mr. Mendoza-Keel?
Very helpful.
If you'll go ahead and step down, you can come up closer to, there's this podium up here. You're welcome to walk as close as that podium so that you can see it more clearly. Now, Mr. Mendoza-Keel doesn't have a microphone presently, so we could also give him one of the hand microphones, which would be fine.
I'm just going to stick it right here.
They're harder to put in the stand than you think.
Mr. Mendoza-Keel, do you see the shadow of your hand, your arm outstretched with your fingers hanging down, indicating an open hand?
Indicating a release, yes.
Okay. I'm going to just try to go about half a second forward if I can. What about here? Do you see your fingers in that same position, or is your hand now closed?
It appears to be closed, yes.
And right there, we actually see your hand in the top left. Your hand's closed at this point?
Not fully, no.
I'm going to show State's Exhibit 4. That's previously been admitted into evidence.
Your Honor, the state just going to be asking for him to identify himself in this video for the third or fourth time. I'd object to cumulativeness.
Overruled.
Zoom in there. So I think we've established this is you flying through the air. Would you agree with me that your right hand is touching the top of Corporal Knight's head in the upper left portion of this frame, State's Exhibit 4?
It is blurry, but I would agree with you, yes.
Thank you. I don't have any, 1 second.
All right, thank you, Mr. Mendoza-Keel. If you'll just come back and sit next to me again.
Yeah, I do have one more question, but the witness can be seated.
Okay, you can still come back next to me.
Mr. Mendoza-Keel, prior to what we just watched, when you were standing in the yard speaking to Deputy Willis, was his hand on his gun at any point?
I do not recall.
Was his hand on his taser?
I don't believe so.
No further questions.
All right, thank you. And redirect.
Can I get the lights?
We can.
Mr. Mendoza-Keel, did you at any point while you were being taken under arrest ascertain why you were being arrested?
Objection asked and answered.
Sustained.
Mr. Mendoza-Keel, were your concerns satisfied as to why you were being arrested on
No
April
objection.
22nd?
Overruled on those grounds.
Were your concerns satisfied?
No, they were not.
All right, no further questions.
All right, and we have questions from the jurors. Looks like we will. Thank you. All right, I'll have the attorneys come forward. All right, the first question is, how far away are the closest neighbors?
No objection.
Objection. Well, I guess I kind of object on relevancy. I just don't see how it's relevant, but no objection really. So.
I'll ask it. I don't see any harm in it. The second question, I think you all know the answer. Were Mr. Keel's felonies for violence?
Can't ask that, or can't answer.
Um,
Oh, come on.
The state didn't make a 403 motion as to felony priors in this case. I don't have an objection to the question. I understand the court's not likely to grant it, but the state doesn't have an objection.
Definitely.
Yeah, okay.
I'm not asking that question. Okay, thank you. So I have one question for you, Mr. Mendoza-Keel. How far away are the closest neighbors?
About 400 feet away.
All right, thank you. Any follow-up from either counsel?
Nothing from me, Your Honor.
No, Your Honor.
All right, just to double check, I want to make sure that there's no further questions from our jurors. And there are not. Mr. Mendoza-Keel, step down.
Yes, Your Honor.
All right, thank you. And you may step down, Mr. Mendoza-Keel. And at this time, does the defense have any further witnesses?
No, Your Honor, the defense rests.
All right, thank you. Does the state wish to present any rebuttal?
No, Your Honor.
All right, with that, both parties have rested. We're not quite ready to proceed to closing arguments just yet. So at this time, we're going to take our afternoon break. I don't believe that we'll be ready for the jury until at least 3 o'clock, maybe later than that, but everybody can comfortably assume that we're going to be working until at least 3 o'clock. Got a lot of photocopies to make and other things as well. So you can safely assume it'll be at least that long, and we'll let you know as soon as we're ready for you, okay? Thank you. And I'll just remind the parties of the admonition. At this point, you've all heard all the evidence that's going to be presented in the case, but the case has not been turned over to you for your deliberations. You still must not talk about the case amongst yourselves at this time. So we'll see you soon. All right, please be seated. The jurors have left the courtroom. What I'd like to do is take about a 10-minute break ourselves. I want to get some things organized and give everybody the chance to use the restroom, and then we'll pick up with arguing the remaining instructions and get ourselves ready for closing arguments as efficiently as we can. Was there anything that either council needed to put on the record at this time?
No, Your Honor.
Nothing for us, Your Honor.
All right, thank you. All right, we're back on the record in State of Arizona versus Francis Mendoza-Keel, CR 2025-00513. And the court will note the presence of both counsel for the state as well as the case agent as well as defense counsel and Mr. Mendoza-Keel, and the jury is not present. Just to take up one, I think, easy item, the court did receive the verdict forms with the requested changes I made of the state. I appreciate that. There was on the second form, I noted that the guilty, not guilty, if you look at that, they've got that on there twice. Above the four-person signatures. We need to remove that. Aside from that, I thought that they looked good. If we could just make that change to the third verdict form. Did you have a chance to look at those, Mr. Hartman-Strawn?
Yes, I did. I was able to view it on their laptop.
All right. Other than that change that I'm noting, did you see anything that was problematic from the defense perspective?
Nothing from our perspective, Your Honor.
Did either of the attorneys for the state see any other problems other than the one I pointed out?
No, Your Honor.
So with that, I'm sorry for the delay. I've been working as fast as I can, but I've provided the parties with pages 25 through 31, where I included the additional alternate requested instruction from the state. I also included an instruction derived from 4.09 in the standard instructions, the use of physical force in law enforcement. I've tried to have everything that we're possibly going to be utilizing there so that we can address all of that at this point and have everything in front of us and all be on the same page. So did each of you receive that? It's just intended that those would replace the instructions you have from page 25 on.
Yes, Your Honor, the state has that.
Okay. So with that, first, as to the issue of the state's motion to preclude the justification, self-defense, defense based upon untimeliness, the court notes that the motion to preclude came mid-trial after opening statements. It's clear that the Rule 15.2 came to the court as stated by the court just last week, as the state noted from the defense, including that. The court was aware of that coming into the trial, that's the primary defense in the case. But I'll turn it over to you to make any record you wish or any argument you wish beyond that you made this morning, Mr. Kent.
No further argument on preclusion of that justification defense.
All right, Mr. Hartman-Strawn.
Given that, I have nothing to add, Your Honor.
All right, and just for the record, I did review the Medina case as requested by the state. That was a case in which court precluded defendant from necessity defense during trial, and it was preclusion based on untimeliness. As far as I can determine from the Medina case, which was provided earlier, but it's 244 Arizona 361. That was a motion that was made prior to the the trial being ongoing. The court noted that preclusion is not favored when it can be avoided. Here, the court sees as a particularly extraordinary request where it's being made mid-trial after opening statements to have that defense precluded. The court, frankly, relying on Medina, may have granted that, but not after we're in the middle of trial. The court just doesn't believe that is appropriate in the middle of the jury trial. So on that basis, the court is denying the request to preclude justification on timeliness. So with that, I'll turn it over to, let me just put a few things on the record. I want to make sure that I understand what each of you is requesting before I hear your arguments. The court believes that the defense is requesting the standard 404 justification instruction in its entirety, as is provided on pages 23 and 24. I'll note that I added in on page 25 the definition of physical force, which would be appropriate if the court is to give that justification instruction. So that's just my thought that is a defined term and should be included. The defense is also asking for the 38.81 and 38.88 instructions, which are referenced to be used when appropriate in the use notes at the bottom of the standard 4.04 justification instruction. And then I believe that the state's seeking to have the 4.09 instruction for what constitutes lawful use of physical force in law enforcement. I've included that as page 28. And then the state is seeking instead for the court to give the alternate instruction under 4.041 rather than the entirety of 4.04. And then I just left the final instruction on submission to the jury at the end. So do I have that right as to what everyone is seeking?
I think you may have just misspoke. The state is seeking to exclude 4.09, not include.
Oh, if I said so, I certainly understand the state's not seeking that 4.09 be included. That was definitely from the defense. So if I said that, I did misspeak.
I believe, other than that, we agree on the posture we're in.
Okay, so I just want to make it clear where everyone is in that regard as we now proceed with the arguments as to what's appropriate based upon what's been presented in the case. I'll tell the parties up front that I've been researching this all day, and some of the cases that I've been relying on and reviewing are State versus Doss 192, Arizona 408, State versus Fontes 195, Arizona 229. That case is a really interesting one to review because it had a unique. Oh wait, I may be misspeaking. Hold on one second. But the one that I wanted to draw attention to was State versus Flores, 227, Arizona 509. That's a 2011 case that was, it provides a particularly unique and interesting discussion of these same issues It just wouldn't be available in most circumstances because it was a case where a defendant gave up their right to a jury trial in exchange for having the charge reduced to a misdemeanor, and the parties did a trial to the court. The court found the defendant guilty, and then the Court of Appeals is looking at what is appropriate for the court to be making the determination of guilt, and how does 409 factor in, and the use of, when does the unreasonable force come in, and those sorts of things. It wasn't specifically looking at jury instructions, but the court's very much relying on those same statutes in determining whether or not the trial court erred in its determination of guilt of the defendant. And you just wouldn't get that same thing, but for that unique posture where the trial court decided the case and there wasn't a jury, and they were looking back at the decision made by the court. So that case was one that the court found the discussion helpful in as well. So I'm going to turn it over to the defense in regards to inclusion of justification instruction 409, and then also the two 38.81 and 38.88.
Yes, thank you, Your Honor. I have also been kind of trying to dissect sort of what statutes basically substantiate the argument we're making here. And we're very clearly making a justification self-defense claim as to why my client is not guilty. So that's why we think that instruction is very necessary. However, it's our position that you cannot read that statute and understand that statute, and especially understand the defense that we are bringing without also including 409, because it's our position that those act as interlocking statutes to the extent, or in this particular context. There is an exception to justification for self-defense. That is Part B section, or Part B2, excuse me. And it's that essentially any arrest that a person's being known by a peace officer is being made by a known peace officer or should have been known peace officer, regardless whether that arrest is lawful or unlawful, can't be resisted unless the force exceeds that allowed by law. And what we're sort of getting at that last part of the statute, not that middle clause of whether the arrest is lawful or unlawful, but actually whether the force exceeds by law. And here then is why I need 13409 is this is what describes this is what prescribes when law enforcement is allowed to use physical force while making an arrest. And so we're not getting into the merits of the arrest. We're not getting into whether the arrest was lawful or unlawful, as in whether there was probable cause or factual basis, any of those things. What we are getting into is whether the officer was allowed to use physical force in this arrest. And 13409 sets out when an officer is allowed to use physical force during an arrest. And we feel very, the main tenet of our defense is that the second of the three-prong test was not met. And therefore, if that second prong is not met, my reading of that statute is that then the officer cannot use physical force during an arrest. It's very clear. All three requirements must be met is what that law says. So therefore, if the officer does not meet those three requirements, all three of them, under 13409, then turning back to 13404, the person is not resisting a lawful or unlawful arrest. The officer has immediately exceeded the force allowed by law by employing any amount of physical force if they haven't met the three requirements under 13409. And so I'm asking the jury to assess whether that initial decision to use physical force against Mr. Mendoza-Keel was justified. My position is that it's not. And therefore, Mr. Mendoza-Keel is able to utilize 13404 without triggering Section B2 because he's not getting into that middle contained clause. He's actually getting into that final part, that final clause, that final part of B2, where the peace officers exceeding the force allowed by law because they weren't allowed to use any force in the first place. Thank you.
All right, thank you. From the state?
Your Honor, the state's position remains that 13409 has no bearing on this case. The whole chapter 4 of Title 13 is about justification defenses. There's no law enforcement officer who's a defendant in this case. 13409 is specifically about when a law enforcement officer is justified in using force, and as would apply in a trial where the law enforcement officer is on trial. Not the case here. The state believes that 404B is, if there's a justification defense allowed, that is the relevant statute here. Back to the question of 404B2, the use of physical force by a peace officer exceeds that's allowed by law. There needs to be a showing that there was physical force used by officers at the start of the arrest sequence. In this case, there's no evidence of that. The evidence that we've heard several times is that they were talking. The defendant was told, at this time you're being placed under arrest, and then he started backing up and got violent. There was no, officers jumping out of their car, guns blazing, pointing immediately without any investigation. The force used to initially initiate the arrest was being told, you're under arrest. That's it. There was no force. There was no physical force or force when the arrest was initiated. There was force used after the defendant got violent, and force had to be applied to gain compliance. So the state, I think, initially moved not only for preclusion of justification based on timeliness, but based on there not being a scintilla, I think the word is the slightest fact supporting that. I would ask for, I guess, a ruling on that issue, whether there's this slightest evidence to allow for a justification defense. And if there is, I would still, the state's position is that 404 would be the only applicable statute in Chapter 4 to instruct the jury on. If we instruct the jury on 404 and 409, I think there's a significant chance it's going to confuse the jury about the issues more than they might already be. Because the justification defense in 409, the remedy there is the action was justified. What's the remedy under 409 if it's not a law enforcement officer on trial, which is what we're in here? I think that issue is open, or at least not immediately clear based on the text of the statute. Look, I did have a chance to very briefly look at State v. Flores. State v. Flores, it does mention 409 and dictates and the appropriate amount of force, but it certainly does not say that there's any indication that that should be read as an instruction to the jury. I understand the court's position about how it's helpful to understanding the posture we're in, but as far as instructing the jury on a justification defense that is inapplicable to a trial such as this, I just don't think there should be any argument that 409 should not be an instruction read to the jury. Anything else? I think I'll leave it there. Thank you.
Great, thank you.
Your Honor, can I just briefly respond?
You may.
Just extremely briefly. We're arguing that the force used exceeds by law. How is the jury to know what force, when use of force exceeds that allowed by law? I'm just asking for the jury to have that information.
Understood. When looking at the instruction for use under 4.09, I have a lot of concerns about providing that to the court. Obviously, the Court of Appeals has relied upon that statute to guide them in determining whether or not there's whether there was an appropriate amount of use used by an officer. The instruction itself, of course, refers to what would be the officers, the defendant throughout, which I think creates a lot of potential confusion if the court were to provide that. What is the defense position on the use and possible confusion of the issues with that instruction?
Your Honor, I mean, I think this is a really interesting legal question, and I hear the concerns of the state in that this is, we're using a statute, or here specifically, an instruction that is usually used when a law enforcement officer is the defendant in a case. However, I guess two things. First, I don't think that changes the logic of what I'm arguing of. How am I to explain what is force that exceeds that which is allowable under Arizona law, unless we have the law that sets forth what is allowable under Arizona law when they're able to utilize force. So I'm going to be talking about that during my closing. So the jury's just going to be seeking about for what force is allowable under by law when we do have a statute on point, a statute which is used at the AZ, it's in the AZ post curriculum. I mean, the chapter they study on when they're allowed to use force, it's 409. So the reason why it's here available for law enforcement when they're the defendant is because they violated the rules that govern what allow them to use force. So it's here because they're usually on trial for this. The issue is that, or it's set forth in this way. I think the way the court corrected it was perfect. Just change out defendant to officer. And I think that just sets forth exactly in sort of Raji language what the plain language of the actual statute sets forth. And it allows the jury to have some clarity as to when or when not law enforcement is allowed to use force. I mean, that is really the crux of the entire defense here. So I think that the court's proposed changes to the current Raji, I think, satisfy any concerns about confusion. I hear that. Again, I hear the concerns about having basically a justification statute used to help instruct the jury as to the parameters of law enforcement's ability to use physical force. We just don't have anything better. This is where it's set forth in law. That's why AZ Post uses it in their instruction to tell officers what is legal as to force. Every officer in Arizona studies 409, and they just study whether or not they're allowed to use force. So the fact that it's classified as in the justification section, I totally understand why to us as lawyers that's confusing. I think it's actually going to be way more confusing to the jury, the actual fact finders here, the actual decision makers, if they don't have this instruction. Because then they're just going to be making up what is allowable force when we actually have something on statute to direct them. So thank you.
All right, thank you. Did you have anything further, Mr. Kent?
Yes, Your Honor. I think it's important to read 404B2 in its entirety. It sounds like we agree there's a resisting of an arrest here. I don't think it's in dispute that the defendant knew the officers to be peace officers. So we're really just on the last two clauses, whether the arrest is lawful or unlawful.
I'm sorry, can you tell me where you are?
13404.
No, I'm there, but where within it?
B2.
B2. Oh, are you looking at the instruction or you're looking at the statute?
I'm looking at the statute, sorry.
Oh, I didn't understand that. All right, thank you. And go on.
So my point is, whether the arrest is lawful or unlawful, obviously the defense's position is that it wasn't. But I don't think that is relevant here because the statute says whether lawful or unlawful. So the question is, what force was used to initiate that arrest? And there's just extremely little force. There's telling him he's placed under arrest. When he backs away, they try to grab his arm. So I just don't understand the defense's position that if we're on the same page so far, how that physical force used in initiating this arrest, regardless of what the law says, how those facts, you're under arrest at this time and potentially grabbing the arm, it could ever be in any universe force that exceeds that allowed by law. That's the state's position.
Right. In the same section, when you were reading from paragraph 14, paragraph 16 from the Flores case moments ago. And if you read a little bit further on, it actually provides a standard from another case as to when using physical force in a resisting arrest is permitted. It says, physical force in resisting arrest is only permitted when the court can find no hypothesis whatever to provide sufficient evidence to support the trial court's conclusion that the officer acted reasonably in physically restraining a person. Now that obviously is a very difficult standard to meet. I think that the argument that that defense is hoping to make and rely on is a very difficult one to achieve. And when the Court of Appeals is looking at a decision made by a judge, that's the standard that they're looking at. Is there no hypothesis whatever to provide sufficient evidence to support what the trial court did in the case? But there is a standard nonetheless where it is acceptable. So it's 404B isn't an absolute. There is a standard that the Court of Appeals has looked at as to where you go when it is unlawful and when it is, you can actually rely on that. Very, very difficult standard to meet, but it does exist. Going back to the state's request that the court make a finding that there has been evidence presented to the court to support a justification defense. The court does believe that through Mr. Mendoza-Keel's testimony that there is a sufficient basis for that instruction to be given and for the defense to be allowed to present that. That's on the other end of the spectrum, a very easy standard to get over for the court to be required to give that instruction. And I think that that's easily met. I think that you can also, I think different eyes may see the video and the initial grabbing of the defendant differently. Like I don't think everybody's going to see that video exactly the same way. There's, as Mr. Mendoza-Keel testified to, he took 2 steps back. You can see him do that in the video. The officer immediately went to physically restrain him, and different people may interpret that use of physical force and everything that came from that differently. So the court does believe that there's a sufficient basis to at least include the defense. So the court is going to give the justification instruction on for the 4.04 as requested by the defense and as is occurring on pages 23 and 24. With that being included, is there any objection? I understand the state's objecting to me giving that at all, but once I've already made that decision, do both parties agree that the definition for physical force, which is suggested to be given in the use notes in the Rajis for the justification instruction, that also should be given as it's included on page 25 there?
No objection, Your Honor.
No objection.
So I will give that also. The use note also suggests the possible use of 38.81 and 38.88. So let's look at those. On page 26, we have the suggested instruction 38.81 that's been requested by the defense, which just describes the process of effecting an arrest.
And Your Honor, If the court's inviting any comment, I included both these in my suggested instructions as the use notes for the 404 instructions, suggest including them. I don't know that either of them get directly to the defense we are making, but I think they both touch on aspects of it and sort of clarify the law around notification to arrestees and to force and restrictions on amount of force to be made. But I do think kind of in the way this case is developed, 409 to the arguments I made earlier are actually more on point at this, to Mr. Mendoza-Keel's exact defense here.
All right, and from the state?
If 4.04 is to be included, the state has no objection to 38.81 and 38.88 being
All right.
included.
With that caveat, I appreciate that from the state. The court notes, I understand that only with the court having already ruled on the 4.04 justification that the court, did you have something?
Yes, so I understand 4.04 is coming in. I just, so we're crystal clear, has this court declining to also include 4.04-1 at this time?
I thought that I hadn't gotten to that yet, but
Okay.
I thought 4.04-1, I was under the impression that everything that's in that is in 4.04, so we can look at that. I could be mistaken about that, but I was just doing them in the page number order that I have them here. I am going to include 38. 38.81 on arrest and the method of arrest under 38.88. So next, if you'd like to look at the 404-1 next, that's on page 29. We can do that. I'm not opposed to that. Can we look at that? So I was just viewing that as just being covered by the language at the bottom of page 23 in the 4.04 instruction. I think it's verbatim, in fact.
Your Honor, while we don't strongly object to this because I think it does, it already includes information that we're asking for to be included anyway under 404, I do agree with the court that it just restates 404 and potentially cause the risk of confusing the jury as to why they have two different 404s and if there's something very different that this one is saying. So
the jury, of course, won't have that.
Oh, right, the numbers, yeah, right.
But the confusion and this just being a duplicate is where my concern is from. Mr. Ken?
I do understand that. The state still would ask that 404-1, as stated here, is included on a separate page. I would be amenable to striking that language from 4.04, so there's not a duplication. I also think, if this is a good time to address this, there's certain parts of 4.04 that I think inarguably are inapplicable, such as deadly use of physical force. So I would be asking to strike certain portions of 4.04, and I think this would be a fair middle ground to basically take the lower portion of 4.04, strike that, and also include 4.04-1.
All right.
Your Honor, could I just respond briefly? Or unless you just want to go.
No, the court is not going to do 4.04 dash 1. It's covered, the exact verbatim language is in the justification instruction, and I think it doesn't provide any benefit. It has a risk of confusion, but I'm willing to go and look at a more refined version of 404. As I stated previously, usually when I've had this same instruction used, it's usually been presented to the court, excising the stuff that doesn't apply. So I'm all ears if you want to refine 404 to the specifics of this case, because I think the jury does get overwhelmed when you give them everything, including a bunch of information that isn't applicable to the case. But I'd like to have the proposals from the parties rather than, that's how I'd like to do it.
I'd move to strike paragraph 4 in its entirety. Defendant may use deadly physical force, that paragraph.
Okay, it's not numbered 4, but just read the beginning of it.
Yeah, a defendant may use deadly physical force in self-defense only to protect against another's use of apparent.
Do you agree with that, Mr. Hartman?
Yeah, no objection to striking that.
All right, I agree. So I will take that out. In the very next paragraph, would you like the court to strike out or deadly physical force so that it reads self-defense justifies the use or threat of physical force only while?
Yes, please.
Yes, Your Honor. Your Honor, I think maybe, and I'm not sure if I'm reading this part of the statute correctly, but it seems like part 3 of these instructions really just has to do with 2 non-law enforcement officers, 2 civilians engaged in a fight where physical force is used in defense, because it talks about, intent to withdraw or withdraw from encounter. That's not an option for one of the parties in this kind of encounter. So if the court wanted to remove that or the state wanted that out, I think that could be removed too without removing instructions that we need.
While you're considering that, Mr. Kent, I'd ask both of you to look at removing in response to verbal provocation alone.
And we'd have no objection to that.
Yeah, I have no objection to removing in response to verbal provocation alone. No objection to removing in response to verbal provocation alone.
All right, and then as to number 3, if the defendant provoked the other's use of unlawful physical force unless A and B.
Now we're talking about 3A and B.
I would want to keep if the defendant provoked the other's use of unlawful physical force, but I don't have any objection to striking unless and subparagraphs A and subparagraphs B.
Your Honor, I'd object to that.
I'll just leave it all as is then. I'm not going to change the meaning or broaden it or do anything to it. either 3 applies or it doesn't. So if the parties don't agree on it, I'm going to leave 3 in. It'll be number 2 going forward. Okay. So going back to 4.09, that actually provides the legal standard for a determination of when physical force becomes unlawful and in effect a crime by law enforcement. The court is going to include this instruction. However, I want to make it clear to I don't want to cause confusion to the jurors. I'm going to just make it clear that by changing defendant to officer, in each of those instances that defendant appears, I agree with the defense that to not provide this to the jury when there's clear law that sets out exactly what the standard is depriving them of information that could be useful to them in making their determination. And when the Court of Appeals have wrestled with that issue, the Court of Appeals has relied on that statute in making its own determination. So with that in mind, the court will utilize it for that reason. All right, I believe that's all of the instructions. I just need to make the changes on the copy that I've working on my desktop and get them printing. Is there anything else anybody need to put on the record at this time?
Nothing from us, Your Honor.
All right. We'll get that done as quickly as I can and get the copies to everyone as quickly as I can. And that'll be all for now. From the record in the State of Arizona versus Francis Mendoza-Keel, CR 2025-00513, both of the state's attorney and case agent are present, the defense attorney and Mr. Mendoza-Keel are present, and the jury is not present. The court understands that the parties looking at the final instructions found a couple of small things. If you'll take me right to those.
Page 22, Your Honor. Middle paragraph, protect against another's use. There's an extra comma between another.
I just got there. Can you say it again?
About the middle paragraph, you must decide whether.
Okay.
Second line, under that line, another's use, there's a superfluous comma after another's.
Okay. I see it. I got it.
And then on page 27, there are 2 number 3s in the list.
So it should just be number 4. Got it.
That's it.
All right. I'll make those changes and get the copies printed out quickly.
The state doesn't need a new copy.
No, I wasn't offering. But and I thought it was so good, I found that, you know, where we found the extra space was actually 3 spaces.
Oh, wow.
Got it down to 1. Changes. All right, we're back on the record. The jury is still not present, but I have called for them. We have all 9 copies of the instructions ready for them. And does the clerk have the, well, actually, we'll do the, we won't do the drawing for excusing the alternate juror until after arguments. So we won't have that today. But I'm intending to read the instructions today, and then we'll come and do closings in the morning and turn it over to the jury for deliberations.
Are you going to read just through 27 or all 29?
I'm going to read all 29. And because I don't reread anything to them after the closings. I know a little bit of the language is like slightly funky, but it's okay. And I did get the corrected instructions with the changes to verdict form number 2. Appreciate that. And I think we're ready to go on those as well. All right, the jury is here.
Everyone,
All right, thank you. Please be seated. All right, and welcome back to the jury. I knew it was going to be longer than 3 o'clock, but it was longer than I anticipated, and I apologize and appreciate everybody being patient with us. Honestly, our trial has moved along so swiftly that we still had some things we had to do at the conclusion of the presentation of evidence, and there are some things you just can't do until we get to that point where all the evidence has been presented in the case. So that's where we are, and at this time, I'm ready to read the final instructions to everyone. Before we pass those out, everybody's going to take the preliminary instructions that you received on yesterday and take those out of your binders and pass those down to Ernie. He'll collect those from you. And then a fresh copy of the final instructions, which will control your deliberations. You're going to receive a copy of those and put those in the binder instead. And that's what you're going to rely on from this point forward. All right, and with that, if it's not obvious, I'm going to read the instructions to you here this evening, and then we're going to depart for the evening, excuse you for the evening. We'll come back for closing arguments in the morning, and at that point, I anticipate the case being turned over to you for your deliberations sometime early mid-morning tomorrow. So we're way ahead of schedule, so just to if anybody's stressed out about the schedule or anything like that, from everybody's perspective here, we're ahead of schedule and doing great in that regard. So at this time, I'm going to read the instructions to you. Just as with the preliminary instructions, it's entirely up to you whether you want to read along with me or if you just want to listen as I read the instructions, and I'll begin those now. It is your duty as a juror to decide this case by applying these jury instructions to the facts as you determine them. You must follow these jury instructions. They are the rules you should use to decide this case. It is your duty to determine what the facts are in the case by determining what actually happened. Determine the facts only from the evidence produced in court. When I say evidence, I mean the testimony of witnesses and the exhibits introduced in court. You should not guess about any fact. You must not be influenced by sympathy or prejudice. You must not be concerned with any opinion that you feel I have about the facts. You, as jurors, are the sole judges of what happened. You must consider all these instructions. Do not pick out one instruction or part of one and ignore the others. As you determine the facts, however, you may find that some instructions no longer apply. You must then consider the instructions that do apply, together with the facts as you determine them. The state has charged the defendant with certain crimes. A charge is not evidence against the defendant. You must not think that the defendant is guilty just because of a charge. The defendant has pled not guilty. This plea of not guilty means the state must prove each element of the charges beyond a reasonable doubt. The law does not require a defendant to prove innocence. Every defendant is presumed by law to be innocent. You must start with the presumption that the defendant is innocent. The state has the burden of proving the defendant guilty beyond a reasonable doubt. This means the state must prove each element of each charge beyond a reasonable doubt. In civil cases, it is only necessary to prove that a fact is more likely true than not, or that its truth is highly probable. In criminal cases such as this, the state's proof must be more powerful than that. It must be beyond a reasonable doubt. Proof beyond a reasonable doubt is proof that leaves you firmly convinced of the defendant's guilt. There are very few things in this world that we know with absolute certainty. And in criminal cases, the law does not require proof that overcomes every doubt. If, based on your consideration of the evidence, you are firmly convinced that the defendant is guilty of the crime charged, you must find him guilty. If, on the other hand, you think there is a real possibility that he is not guilty, you must give him the benefit of the doubt and find him not guilty. You must decide whether the defendant is guilty or not guilty by determining what the facts in the case are and applying these jury instructions. You must not consider the possible punishment when deciding on guilt. Punishment is left to the judge. You are to determine what the facts in the case are from the evidence produced in court. If an objection to a question was sustained, you must disregard the question and you must not guess what the answer to the question might have been. If an exhibit was offered into evidence and an objection to it was sustained, you must not consider that exhibit as evidence. If testimony was ordered stricken from the record, you must not consider that testimony for any purpose. The state must prove guilt beyond a reasonable doubt based on the evidence. The defendant is not required to produce evidence of any kind. The defendant's decision not to produce any evidence is not evidence of guilt. In their opening statements and closing arguments, the lawyers have talked to you about the law and the evidence. What the lawyer said is not evidence, but it may help you to understand the law and the evidence. Some of the exhibits that have been admitted into evidence have had portions deleted from them for legal reasons. Do not concern yourselves with the reasons why some portions of the exhibits have been deleted. Do not speculate upon what the deleted portions might or might not reveal. Evidence may be direct or circumstantial. Direct evidence is the testimony of a witness who saw, heard, or otherwise sensed an event. Circumstantial evidence is the proof of a fact or facts from which you may find another fact. The law makes no distinction between direct and circumstantial evidence. It is for you to determine the importance to be given to the evidence, regardless of whether it is direct or circumstantial. In deciding the facts of this case, you should consider what testimony to accept and what to reject. You may accept everything a witness says, or part of it, or none of it. In evaluating testimony, you should use the tests for truthfulness that people use in determining matters of importance in everyday life, including such factors as the witness's ability to see or hear or know the things the witness testified to, the quality of the witness's memory, the witness's manner while testifying, whether the witness had any motive, bias, or prejudice, whether the witness was contradicted by anything the witness said or wrote before trial, or by any other evidence, and the reasonableness of the witness's testimony when considered in the light of the other evidence. Consider all of the evidence in the light of reason, common sense, and experience. The testimony of a law enforcement officer is not entitled to any greater or lesser importance or believability merely because of the fact that the witness is a law enforcement officer. You are to consider the testimony of a police officer just as you would the testimony of any other witness. You must evaluate the defendant's testimony the same as any witness's testimony. You must not consider any statements made by the defendant to a law enforcement officer unless you determine beyond a reasonable doubt that the defendant made the statements voluntarily. A defendant's statement was not voluntary if it resulted from the defendant's will being overcome by a law enforcement officer's use of any sort of violence, coercion, or threats, or by any direct or implied promise, however slight. You must give such weight to the defendant's statement as you feel it deserves under all the circumstances. You have heard evidence that the defendant has previously been convicted of a criminal offense. You may consider that evidence only as it may affect the defendant's believability as a witness. You must not consider a prior conviction as evidence of guilt of the crime for which the defendant is now on trial. The crime of aggravated assault requires proof of the following. 1, the defendant committed an assault, and 2, the defendant knew or had reason to know that the person assaulted was a peace officer. The crime of assault requires the proof that the defendant knowingly touched another person with the intent to injure, insult, or provoke that person. The crime of disorderly conduct requires proof that the defendant knowingly or intentionally disturbed the peace or quiet of a neighborhood, family, person by engaging in fighting, violent, or seriously disruptive behavior. Intentionally or with intent to, as used in these instructions, means that a defendant's objective is to cause that result or to engage in that conduct. Knowingly means that a defendant acted with awareness of or belief in the existence of conduct or circumstances constituting an offense. It does not mean a defendant must have known the conduct is forbidden by law. Peace officer means any person vested by law with a duty to maintain public order and make arrests. A defendant is justified in using or threatening physical force in self-defense if the following two conditions existed. 1, a reasonable person in the situation would have believed that physical force was immediately necessary to protect against another's use or apparent attempted or threatened use of unlawful physical force, and 2, the defendant used or threatened no more physical force than would have appeared necessary to a reasonable person in the situation. Self-defense justifies the use or threat of physical force only while the apparent danger continues, and it ends when the apparent danger ends. The force used may not be greater than reasonably necessary to defend against the apparent danger. The use of physical force is justified if a reasonable person in the situation would have reasonably believed that immediate physical danger appeared to be present. Actual danger is not necessary to justify the use of physical force in self-defense. You must decide whether a reasonable person in a similar situation would believe that physical force was immediately necessary to protect against another's use, attempted use, threatened use, apparent attempted use, apparent threatened use, or unlawful physical force, of unlawful physical force, or you must measure the defendant's belief against what a reasonable person in the situation would have believed. The threat or use of physical force is not justified, 1, to resist an arrest that the defendant knew or should have known was being made by a peace officer, or by a person acting in a peace officer's presence and at the peace officer's direction, whether the arrest was lawful or unlawful, unless the physical force used by the peace officer exceeded that allowed by a law. Or 2, if the defendant provoked the other's use of unlawful physical force, unless A, the defendant withdrew from the encounter or clearly communicated to the other person the defendant's intent to withdraw, reasonably believing that the defendant could not withdraw from the encounter, and B, the other person nevertheless continued or attempted to use unlawful physical force against the defendant. The state has the burden of proving beyond a reasonable doubt that the defendant did not act with such justification. If the state fails to carry this burden, then you must find the defendant not guilty of the charge. Physical force means force used upon or directed toward the body of another person and includes confinement, but does not include deadly physical force. An arrest is made by actual restraint of the person to be arrested, or by such person's submission to the custody of the person making the arrest. No unnecessary or unreasonable force shall be used in making an arrest, and the person's arrest shall not be subjected to any greater restraint than necessary for the person's detention. When making an arrest without a warrant, the officer was required to inform the defendant of the officer's authority and the reason for the arrest unless, 1, the defendant was engaged in the commission of a criminal offense, or 2, the defendant was pursued immediately after the commission of a criminal offense, or 3, the defendant was pursued immediately after an escape, or 4, the defendant fled or forcibly resisted before the officer had the opportunity to inform the defendant, or 5, the giving of such information would have imperiled the arrest. An officer was justified in using threatening physical or threatening, An officer was justified in using or threatening physical force in law enforcement if 1, the officer was making an arrest or detention of another person, and a reasonable person in the situation would have believed that using or threatening physical force was immediately necessary to effect the arrest or detention, and 3, the officer made known to the other person the purpose of the arrest or detention. The officer believed that the other person knew the purpose of the arrest or detention, or the officer could not have reasonably made known to the person to be arrested or detained the purpose of the arrest or detention. And 4, a reasonable person would have believed that the arrest or detention was lawful. The use of physical force in law enforcement is justified only when the danger continues, and it ends when the danger ends. The force used may not be greater than reasonably necessary to defend against the danger. Actual danger is not necessary to justify the use of physical force in law enforcement. The use of physical force is justified if a reasonable person in the situation would have reasonably believed that there was an immediate physical danger. You must measure the officer's belief against what a reasonable person in the situation would have believed. And this case is going to be submitted to you tomorrow, but this is the final instruction that goes along with submission. The case is now submitted to you for decision. When you go to the jury room, you will choose a foreperson. He or she will preside over your deliberations. I suggest that you discuss and then set your deliberation schedule. You are in charge of your schedule and may set and vary it by agreement and the approval of the court. After you have decided on a schedule, please advise the bailiff. You are to discuss the case and deliberate only when all jurors are together in the jury room. You are not to discuss the case with each other or anyone else during breaks or recesses. The admonition I have given you during the trial remains in effect when all of you are not in the jury room deliberating. After setting your schedule, I suggest that you next review the written jury instructions and verdict forms. It may be helpful for you to discuss the instructions and verdict forms to make sure that you understand them. Again, during your deliberations, you must follow the instructions and refer to them to answer any questions about applicable law, procedure, and definitions. Should any of you or the jury as a whole have a question for me during your deliberations or wish to communicate with me on any other matter, please utilize the jury question form that we will provide you. Your question or message must be communicated with me in writing and must be signed by you or the foreperson. I will consider your question or note and consult with counsel before answering it in writing. I will answer it as quickly as possible. During your deliberations, you must not communicate with or provide any information to anyone by any means about this case. You may not use any electronic device or media, such as a telephone, cell phone, smartphone, or computer, the internet, any internet service, or any text or instant messaging service, or any internet chat room, blog, website, or social media to communicate to anyone any information about this case or to conduct any research about this case until you are discharged. Remember that you are not to tell anyone, including me, how you stand, numerically or otherwise, until after you have reached a verdict or have been discharged. All 8 of you must agree on the verdict. You must be unanimous. Once all 8 agree on a verdict, only the foreperson needs sign the verdict form on the line marked foreperson. You will be given 4 forms of verdict. The verdict forms read as follows, and there is no significance as to the order in which the options of guilty and not guilty are listed on the verdict form. Verdict form 1 reads, "We, the jury, duly impaneled and sworn in the above entitled action, and upon our oaths, do find the defendant, Francis Cruz Mendoza-Keel." Then there's a line, there's the word guilty and a line to check if that's your finding. Then there's an indication of not guilty and a line to check if that's your finding. Of the charge of aggravated assault against Colin Knight on or about April 22nd, 2025, as set forth in count 1. And then there's a place for the foreperson to sign and indicate their juror number. Verdict form 2 is very similar. It states, "We, the jury, duly impaneled and sworn in the above entitled action, and upon our oaths, do find the defendant, Francis Cruz Mendoza-Keel, and then again, guilty and not guilty with lines for findings as to each of those, of the charge of aggravated assault against Jeff Willis on or about April 22nd of 2025, as set forth in count 2, and again, a signature line and juror number line for the foreperson. Verdict Form 3 reads, we, the jury, duly impaneled and sworn in the above entitled action, and upon our oaths do find the defendant, Francis Cruz Mendoza-Keel, again, check the spots to check next to guilty and not guilty, of the charge of disorderly conduct against Howard Leventhal on or about April 22nd of 2025, as set forth in count 3, and again, a signature line and juror number line at the bottom. And then verdict form 4, we, the jury, duly impaneled and sworn in the above entitled action, and upon our oaths, do find the defendant, Francis Cruz Mendoza-Keel, and again, a spot to check guilty or check not guilty, of the charge of assault against Howard Leventhal on or about April 22nd of 2025, as set forth in count 4. And then there's a place again for the foreperson to sign and indicate their juror number. If I could briefly have the attorneys come forward for a moment. Instruction for the defendant not having the burden to produce any evidence, it would have been appropriate to eliminate the last sentence that says the defendant's decision not to produce any evidence is not evidence of guilt. From my perspective, that sentence shouldn't have been there because the defense did present a case. It's still appropriate from the court's perspective to keep the rest of the instruction making it clear that the defendant has no burden to produce any evidence, but it shouldn't have included the decision not to produce evidence. Do the attorneys all agree?
Kevin Kent, state agrees.
Dana Armstrong, state agrees.
So what I'd like to do to correct that is just bring it to the jury's attention on page 7 and instruct them to cross out that last sentence and send a mistake on the court's part.
I have another issue.
Okay, go ahead.
Page 18, disorderly conduct. There's no.
Page 18?
Mm-hmm.
Okay.
There's no or. There should be an or in family neighborhood person.
I'm not on the right page. Page 18. You should be family comma, well person.
Statute doesn't have the Oxford comma, but I'll defer to the court.
All right. I'll make those corrections with them. Thank you. Can I just ask? Sorry. Aside from that, the parties agree with how they were read?
Yes.
Okay, thank you. All right. As I was reading the instructions, I noticed a correction on page 7. If everyone on the jury will turn to page 7. I'm going to instruct all of our jurors to cross out the last sentence there, as the defense did present a case and present evidence in the case. The court is going to instruct you to cross out the sentence that reads, the defendant's decision not to produce any evidence is not evidence of guilt. That was mistakenly left in there by myself. I want you to disregard that sentence, as it should not have been there. One other small item on page 18. It should read, the crime of disorderly conduct requires proof that, 1, the defendant knowingly or intentionally disturbed the peace or quiet of a neighborhood, family, comma, and then it should have the word or, comma, person, comma. So if you'll just add that or, comma, and then get that between family and person so that it reads correctly. That is all we have for you for today. I want to thank the jury for your patience and for your diligence in the case. Appreciate all the questions that you had for our witnesses throughout the presentation of the evidence here today. At this time, you are excused for the evening. Please remember the admonition still applies. You still can't talk to anybody about the case at this point. Can't do that till the end of your deliberations. So tomorrow we'll come back at 9 o'clock and be ready to go with the closing arguments. And upon the conclusion of those arguments, we'll turn the case over to you for your deliberations. And we're well ahead of schedule. So everybody have a good night. We'll see you back tomorrow at 9 o'clock. All right, the jury has left the courtroom, and at this point, a few minutes before 5, did anybody have anything that they needed to bring up, or can we break for the evening?
Nothing from the state.
Nothing from us, Your Honor.
All right, I'll try to be available at 8:30 tomorrow. If there's anything that comes up, we'll also try to have, if you want to be in here and just make sure everything's set up however you want so that we can start at 9 o'clock, the court would appreciate that. And have a good night.
And Your Honor, I'm so sorry, just to clarify, do you want us here for sure at 8:30? Is that the instruction?
Not unless the parties believe that there's something that you need to address at 8:30. So
Okay.
if you'll give each other a heads up if there is such a thing. Otherwise, I don't expect you to be here right at 8:30. I just would like you to be here early enough that you can do any preparations that you have so that you're just ready to go seamlessly at 9.
Absolutely. Thank you, Your Honor.
All right, thank you.